urgent matter. I want to move tomorrow one.
Wait for listing, please give it to the courtmaster.
My lord, with regard to item number 38 of today's list,
Yes.
I could not contact the petitioner, and the petitioner's husband was in fact in contact with me. He has expired. I could not contact the petitioner. I don't know whether she is alive or not. So I need to issue a letter to her. Ascertain.
Will adjourn it for a month?
Or for 2 weeks.
Okay. Both sides will be represented. On the prayer made by stay the whole under counsel for the petitioner. The matter stands adjourned today to enable him to obtain appropriate instructions. This after 2 weeks. Yes.
May I please ask? Lordship, I beg to mention item number 6. This matter relating to civil bench 2 matter, Lordship. It might be wrongly listed before the
Number 2.
It's number 6, Lordship.
6. Okay. 6. List the matter before approval bench.
Next. Matter.
May I please, Lordship? Lordship, I beg to mention item number 13, Lordship. 13, Lordship.
Yes.
In this matter, Lordship, I am going to file Lordship affidavit reply, Lordship. Lordship, which time may be granted?
Item 13.
13.
Just a moment. Item 13. I think that case is something. List after 2 weeks, so both sides are represented. List after 2 weeks to handle the land counsel for the petitioner to file affidavit and reply. Yes.
I beg to mention item number 62. Engage senior counsel out of station kindly. Item 62. Supplementary list.
Okay. When?
21 Monday.
Okay, list on 21. 8/20/23 on the prayer made by land counsel for the petitioner.
I beg to mention item number 17, Lordship. In this matter, the CJSC, they have filed their affidavit, Lordship. We seek 1 week's time to file our reply to it, Lordship.
And we get 2 weeks because next week is with Tyler.
Lordship.
Both sides are represented. List after 2 weeks to enable the land counsel for the petitioner to file affidavit and reply in the matter.
Lordship. Deeply obliged.
May I please, Your Lordship? I beg to mention item number 41. Order has already been complied with, Lordship.
Okay.
Made the contempt petition is closed.
41.
41.
Okay, both sides are duly represented. Your name?
S.A. Akil. S.A. Akil.
S.A.
Akil.
Akib. Land counsel upon the instructions. Counsel for the petitioner upon the instructions submits that the order of the court has been complied with and therefore he has instructions not to press the matter. Accordingly, this contempt petition stands closed.
May please the Lordship, my lord, I beg to mention item number 31, my lord. I am for the respondents, my lord. We need to file an affidavit. The affidavit has not come yet, my lord. It will come from Delhi.
You have taken consent?
Yes, my lord. I have taken consent from the other side.
Interim order is there, my lord.
Interim order is in their favor, my lord.
Okay, both sides are represented. On the prayer made by Mr. D.P. Bora, counsel for the respondent numbers 2 and 3. List after?
My lord, may I pray for a date because my lord, the council from Kolkata will come. So a fixed date in the month.
Okay, after 2 months, give a date. After 2 weeks. Based on so and so, as to enable the
11 September.
Yes, my lord.
learned counsel for the counsel for respondent numbers 2 and 3 to file affidavit at least 2 days prior to the next date of listing. Interim order past release stands extended till the next date of listing.
Oblige, my lord.
List on so and so.
May I please, Your Lordship? Lordship, item number 2 of Delhi list and another item number 42 of orders. May this matter be adjourned for 2 weeks.
For 2 weeks. item 2 and 42. 42,
42, yes, Lordship.
list after 2 weeks as paid for well and counsel for the petitioner.
Applies, Lordship.
May I please put listing of a IAM and
Give the listing prior to the court master.
less.
Daily list item number 1 for Lushan.
Yes,
May I please? This case is relating to selection appointment. Your Lordship. Petitioner was selected as well as approved, but he was not appointed till date. Similarly situated person, they have already appointed your Lordship. So at this stage, your Lordship, the family notice maybe let them to appear, your Lordship.
in your synopsis, you have not given, when was the post advertised? What is the date of application? When did it, when the,
Advertisement, your Lordship will find
no, just tell
notification.
me,
Notification.
just tell me, when was the date of initiation of the recruitment process?
My lord,
When was the process for recruitment initiated?
my lord. My lord, 2000, your Lordship will kindly peruse page 24, your Lordship.
Any difficulty in telling the court, or should I read it? Any difficulty in addressing the court, or should I read it? If I read it, I don't need a lawyer for motion. If I have to read it, then I don't require a lawyer to address me.
No, no, I shall read it.
Then tell me the date. I'm just asking you a date, and you're not giving me the date you want me to read.
Date, your Lordship, 29 January 2005, your Lordship.
2005. Then we'll have to dismiss it. 2005
My lord,
recruitment process was there.
my lord,
Do you think it is still continuing in 23?
my lord, dear, yes, they have not taking any contact.
After 1 year, this recruitment process will go to an end.
My lord,
Somebody has been appointed.
against my will, I don't know, they have not informed anything, my lord, to me, that
Oh, I never knew it, that you have to be informed. After every recruitment process was, supposing in the APSC or in the UPSC, 5 lakh people apply for the recruitment process. So the government will have to reply to 5 lakh people, informing them who has been appointed, who has not been appointed.
Here is only 4 people here. 4
No,
persons.
I am asking you, see, if that is a principle of law,
My lord.
that means that will apply in all
4
recruitment,
persons.
even in UPSC, APSC. That will be the law.
That's a grade 4,
No, no,
four
you
year.
see, whether it is grade 4 or grade 3, is the rule prescribed so?
After publishing in the notification, he is aware regarding that, your lordship.
No, no.
Otherwise, they have not given any contact, given any intimation to the petitioner, your lordship. There's
Lordship,
a
he
full-
has filed number
great-
of petitions, Lordship. Lordship may
full-
kindly peruse annexure 10,
great
page
full
60,
employee.
Lordship.
Annexure 10,
Yes, Lordship, page 60.
60.
Lordship, he has approved, this has been duly considered and he has been informed that his representation could not be considered, Lordship.
Oh, this is speaking out of
Yes,
28
Lordship,
March.
this was passed after the order of this honorable court, Lordship.
It is the impugn order, your lordship.
No, Mr. Chaudhary, we can't consider
Page
this.
60, your lordship.
This can't be considered now. 2005, if that recruitment was of 2005, we can't allow you to challenge it now.
In page 61, Lordship, and paragraph, third paragraph, whereas Sri Govinda Dekar did not claim the matter in due time, hence it is difficult to take a decision now on a recruitment process which was completed 17 years back.
Oh,
They have served that impugn order, your lordship, but earlier they have not they have not given any notice. They have also duty to inform the petitioner, your lordship.
okay.
Whether they have informed anything, your lordship, let them to show, your lordship. After selection approval, they have not they have not intimated anything later, your lordship. Anything order passed to the petitioner, your lordship. There is a grateful employee, your lordship,
No, I understand.
my lord. He is not aware regarding that after giving the publishing in the notification, your lordship.
Okay.
He is not.
heard Mr. Arun Chaudhary, counsel for the petitioner, and
This
Mrs.
resume
M.
also-
Bhattacharjee, an additional senior government advocate appearing for the respondents. Next para. On a the by filing this replacement in Article 226 of the Constitution of India, the grievance of the petitioner is that after the closure of recruitment process, which was initiated by the advertisement dated 3/1/2005 for filling up the grade 4 post in the under the Directorate of Social Welfare. Sorry, District Social Welfare Officer Mangalday, the petitioner had approached this court by filing writ petition on Article 226 of the Constitution of India, which was registered as WBC 3636 of 2022.
Oh, for my sake.
And thereafter, as the order of the court to order of the court directing the respondent authorities to take a decision within a reasonable period, was not complied with, the petitioner had filed a contempt petition being con case C 623 of 2022. Whereby the contempt petition was closed with a direction to the petitioner to approach the authorities again. Which is by order dated 11/11/2023. It was closed with actions also. So accordingly, the petitioner submitted a fresh representation to registered post with AD, which was posted on 30 January 2023. And thereupon the respondent number
3, Lordship.
number
3.
three, number 3, I,
Director.
the Director of Women and Child Development, Assam, by a speaking order dated 28/3/2023, rejected the representation of the petitioner on the ground that the selection was completed in the year 2005 and the record could not be traced out in their department, and moreover, as the petitioner did not agitate his claim within a reasonable time, the authorities expressed their inability to take a decision on the recruitment process, which was completed 17 years back. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner had applied for grade 4 post and was not aware of the completion of the recruitment process. It is submitted that the respondent authorities had a duty to inform the court about the completion of the recruitment process, which was not done, and therefore this writ petition. Next paragraph. It is noted that just like the learned additional senior government has opposed the prayer made in this petition. Next paragraph. It is noted that as per order dated 3/6/2022, passed in WBC 3636 of 2022, this court had observed this court had taken note of the delay and latches on part of the petitioner to file WBC 3636 of 2022. Yet an opportunity was granted to the petitioner to submit a representation to approach the authorities with his grievance. Full stop. In the contempt petition filed by the petitioner, the observation of this court made in paragraph 3 of the said order, 3 and 4 of the said order is quoted below, page 36. Said order dated 11/11/20 is quoted below. The petitioner had approached this court again by filing WBC 257 of 2023. And this court once again directed the petitioner to file a fresh representation before the Director of Social Welfare Assam, allowing 3 months time to the said authority to dispose of the representation. This court order dated 20 January 2023. Next para. The it is observed that the recruitment process was initiated by advertisement having reference to letter of the respondent number 3 dated 3/1/2005. Full stop. As per the contents of order dated, speaking order dated 28/3/2023, the petitioner appeared in the interview on 11/11/2005. And the district social welfare officer, Darang Mangalai, appointed roll number 21, 22, and roll number 5, and 5. Full stop. After the appointments are made, the recruitment process comes to an end. Full stop. Therefore, the court is inclined to hold that the challenge made to the recruitment process, which had concluded in the year 2005, after 17 years, would be vitiated on the ground of delay and latches. This is an appropriate case to invoke the principles of the doctrine of the maxim of vigilantibus, vigilantibus, non-dormantibus, dormantibus. Next word, jura, jura. Next word, subvenient, subvenient. Meaning thereby that the law will assist only those who are vigilant about their rights and not those who sleep over it. Full stop. According to the court, does not find any merit in the writ petition, and the writ petition is dismissed in the motion stage without issuance of notice on the respondents.
Obliged, Your Lord.
Meet regards.
Yes,
Yes, my lord. This, I have a simple prayer. Here, my lord.
no,
The
your
petitioner-
prayer is most simple
Yes.
and it brings smile to my face. In your synopsis, you are writing that the petitioner is a boy. And in your affidavit, he is 37 years old.
Yes, yes. Now.
I just remembered few
Yes.
youth leaders.
My lord, this is not happily worded because this was drafted by Cambodia.
No, no, whatever be, but if he's a boy of 37,
Right.
then I
Now
remember
he is
few,
37.
I remember few very prominent names, student leaders.
Yes, my lord. The thing is this, my lord, his father was a driver in the health department, health service. My lord died in
2005.
2005. Thereafter, he submitted the application, nothing has been, then joint director sent it to the.
Mr. Monto, only two questions.
Yes, my lord.
Number one, a vacancy of 2005 must be there.
Yes.
Number one. Second question is that if you read NC Santosh, there the Supreme Court has said that the policy which is prevailing at the time of consideration will prevail.
Yes.
Now that policy is not there.
No, now the question is, my lord, there should be a logical end to everything. Now, it will be decided by the district level committee whether he is entitled or not. My prayer is to place before the district level committee a direction to.
It will be non-compliable order.
Yes,
And it will be contrary to.
innocuous order, my lord. It is innocuous order.
No, no, no. It will be non-compliable order. Because our High Court has held that the application which are detained. The other principle applies, which is that you have been able to survive for so many years.
The thing is this, my lord. My prayer is, as there should be a logical end to it. That it may be placed before the district level committee. District
No,
level
we'll-
committee
we'll-
may
we'll close it.
accept or reject.
No, no, we'll bring quietus to the issue by dismissing it right now.
Yes. I have a very simple prayer. If this, my lord, it will.
No, Mr. Mahato.
There should be a logical end to it.
We'll bring a logical end. Don't worry about it. We'll not keep it pending. We'll bring a logical end. And there's a very old saying, a very renowned lawyer before my times, Kalimuddin Sahab.
Yes.
He used to say that one always gets the person who loses gets the right of appeal.
Yeah, but here nothing will happen hereafter, my lord.
But Mr. S.K. Mahanta, counsel for the petitioner. Now, I think you agree to the prayer of Mr. Mahanta?
Yes,
You know what?
up to your lordship, because it is really delay.
No, no. Do you agree to the prayer? My question is, Mr. Mahanta, do you agree with the prayer?
Lordship, because of delay, otherwise I have no objection, but because of delay, how can it be
That will
spared?
be decided by the district level committee.
Already, 2012, it was forwarded to DLC. So again,
Also heard.
I am,
Mr. D. Bora, learned government advocate appearing for respond number 1,
5.
and 5. And this is S. Sharma, standing counsel for the Health Department, appearing for respondent number 2, 3, and 4.
Yes.
Next paragraph. By filing this petition in Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities to has prayed for direction upon the district level committee on compassionate ground, Nalbari, to consider the case of the petitioner on the basis of recommendation made by
Joint Director.
Page.
Joint Director.
respondent number 4, who is the for the joint director of health services, Nalbari. Next paragraph. The case of the petitioner is that his father died in harness on 1/8/2005. And there is no source of income for the family. Full stop. The application for compassionate appointment made by the petitioner was forwarded to the Director of Health Services, Assam, by the respondent number 4, white letter dated, forwarding letter dated 21/9/2005. Full stop. After 6 years, white forwarding letter dated 7/6/2011, the Deputy Commissioner Nalbari sent a name of 24 candidates for consideration for appointment on compassionate ground, where the name of the petitioner appeared at serial number 19. But the district level committee for appointment on compassionate ground, Nalbari, did not take any action. And the matter was not placed before the DLC. The Joint Director of Health Services, Nalbari, by another letter dated 10/4/2012, sent a list to the Director of Health Services where the name of the petitioner appeared. Now, as the candidature of the petitioner was not placed before the DLC, the petitioner has approached this court. Next paragraph. It is noted that the father of the petitioner died on 1/8/2005. And the application for appointment of compassionate ground has not been considered till date. After about 18 years from the date of death of the father of the petitioner, it is inconceivable that a vacancy which arose during the year 2005-2006 would still be available for being filled up on compassionate ground. Although the petitioner is not responsible for the delay of his case not being placed before the DLC, but the inordinate delay in approaching the court has disentitled the petitioner to any relief. Full stop. Just a circumstance, the court is not inclined to entertain this petition and the same is dismissed in the motion stage without issuance of notice on the respondents.
My lord, it is the District level committee will decide whether under the.
No, they can't. If you permit them to do it, there will be chaos. They'll be deciding the 2005, 6, 7 cases.
No court of the petitioner, my lord.
No, I recorded that. It's not your fault.
But in that case, it is not, and it is dismissed again, my lord.
Because now NC Santosh has come, where it says that,
Yes, my lord, the district level committee should decide.
no. Why should we send it? If they can independently decide, it's well and good. But not from the order of the court.
Well, injustice has already been caused to the petitioner
No,
because
no.
of not.
That has been condoned by you, by not approaching, coming in the court on time.
It is. That is the problem, my lord.
17 years is too much. Not 1 or 2 years that we can condone. 17 years is too much. Because it's not only Mr. Mohanta's case we are dealing with.
I know.
There'll be thousands of cases in a year, which we can't handle thereafter.
Yes, yes.
Or
That applies.
Oh. Yes, Mr. Rajbur.
May it please the lordship, my lord. I beg to draw your lordship attention to page 64, my lord, in being ordered. Page 64, it is, in it has been described everything.
Where is this order of WPC 1646? Which page?
My lord. Paragraph 19 of the judgment. Of course, I have not.
Page. Your annex is judgment now.
No.
Give me a copy.
Lordship, if I may, against this particular judgment, the government has actually preferred a writ appeal, and the writ appeal is listed tomorrow. May I pray that the matter will be listed next week, Lordship, by the time some.
Okay. Okay. What is the duly represented? In this case, a reference is made to the judgment and order dated 30 January 2023 passed by this court in WPC 1646 of 2021. Which was which is the non-consideration thereof is the fulcrum of this case. Full stop. At this stage, Mr. D. Baralan, government advocate, has submitted that, as per his instructions, the state has preferred an appeal against the said judgment dated 30 January 2023, passed in WPC 1646 of 2021, which and accordingly prays for an adjournment. Prayer is allowed. List on. We are listing it on Thursday next.
Yes.
Wednesday. Wednesday would be 23rd.
Writ appeal number is 287 of 20.
Being WA number
287 of 23.
23. So accordingly, matters is adjourned today. List on. So you're for?
Forest Department.
Your name, please give it.
MS Sabina Ahmed.
Sabina Ahmed for the department is present. List from last next week.
Obliged to.
All right.
I'm giving you back your judgment. I'm returning back. Yes.
Hello. Case is filed against the withdrawal of the result by the respondent without any cause. Page 34 is the order. Petitioner has applied for an Anganwadi.
Yes, this can't be done.
Lordship.
After initiating the recruitment process, they can't wait.
Let me seek the instructions as to why they have at page number 34.
No, you'll issue a notice because otherwise it comes in motion. It's difficult to handle.
Yes,
matters
Lordship.
Mr. P.J. Sekia, counsel for the petitioner, and Mr. D. Baralan, government advocate appearing for the respondents. Next one. Issue notice of motion returnable on how much time? 2 weeks?
2 weeks, Lordship.
2 weeks. requisite extra copies of the requisition is served on the learned government advocate in course of the day. Next paragraph. The pendency of the requisition shall not be a bar for the respondent authorities to declare the result of recruitment process of for filling up the post of Anganwadi worker and Anganwadi helper pursuant to advertisement dated 4/7/2022 and to bring the said recruitment process to its logical conclusion. You'll get the instruction, or should I make an observation here that you inform the court why it has not been declared?
Yes, your lordship may have observed that.
Yeah. There is on the exit of listing, the government advocate shall obtain instructions as to the impediment for which the impediment of the reasons for which the recruitment process pursuant to advertisement dated 4/7/2022 was not brought to its logical conclusion, and the justification to write to the superior authorities for declaring the result. This after 2 weeks.
Can you fix it date, man?
I'm not fixing it right now, make a mention.
May pleasure losses. Case raised to appointment as master rule worker. Madam. They were working since 1991. Then they,
Just this one. Last item was item 6. 5. Yes,
in 1991,
no,
they
but
were,
yours is a case where you are wanting a successive rate that kind is not permissible. Earlier you got an order.
yes, my lord, by this honorable court, then there nothing
No,
has
but after
been.
that, no, if you don't proceed with that order, then it becomes effective as
Madam, they have passed speaking order also, that speaking order is not supplied to me also, madam. At least they should supply to me in the year 1998, madam. Then
no,
again,
they don't. You see, the government has come up with an RTI, and
but
this,
my lord,
after so many
recently-
years, you can't unsettle things.
no, my lord, recently they have approached these officers communication are there, my lord, that is 21, 22,
You see,
23, my lord.
for a successive rate petition, I'm not inclined to pass an order because it will be constructive legislator which will be operating. Number one, what I can do is that because in the earlier round of litigation, you got a order
Yes,
that your cases will be considered. If not considered, then you would have come in contempt. But having not done so, not on merit, we will not
lordship
entertain.
kindly peruse the last annex.
Let me complete.
Yes, my lord.
Only what I can do is that you can consider your prayer. We'll modify the prayer and consider it only for the purpose of giving you a benefit of Upendas. But this order at page 46,
Yes,
that I'm not repeating again. If you want, we can issue a notice
Yes, sir.
giving you the benefit of Upendas.
yes.
Lordship may still, Lordship may issue notice, Lordship. Upendas,
No, but Upendas, it will be the ground which I am issuing notice.
Lordship,
Not on successive,
Lordship,
Yes, yes.
not on successive rate.
Yes, ma'am.
But I have to make myself clear
yes.
in the
Yes.
order.
Yeah.
But Mrs. K. Devil and counsel for the petitioners and Mr. N. Upadhyay, learned standing counsel for the irrigation department. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner is giving a direction upon the respondent authorities to allow the petitioner to continue their service on fixed pay basis. First off, the learned counsel to the petitioner has submitted that the petitioners were appointed and working prior to 1/4/1993, and accordingly, as the service of the petitioner was not regularized and they remained as master roll worker, the petitioner had approached this court by filing WPC
3824, 2000.
3824 of 1999. And this court by order dated
6/12/1999.
6/12/99 close the petition with the direction upon the respondents to consider the case for to consider the case as early as possible, preferably within 3 months. Next paragraph. The court is of the considered opinion that as that at present the in view of the order dated 6/12/1999 passed in WBC 3824 of 1999, the only issue which survives in this writ petition is the claim is as to whether the petitioner would be and petitioners would be entitled to the benefit of minimum of pay scale as directed by this court in the case of Upendas. Citation to next paragraph. Accordingly, issue notice of motion written within 4 weeks. Requisite extra copies of the writ petition be served on the learned departmental counsel in course of the day. Next paragraph. The pendency of the writ petition shall not be a bar for the respondent authorities to consider the claim of the petitioner and give them the benefit of the ratio laid down by this court in the case of Upendas within brackets of this after 4 weeks.
Highly obliged.
Supplementary cause list 53.
I'll issue a notice in this matter. I'll issue a notice in this matter at this stage.
Only notice.
I'm issuing only a notice.
But not only notice, my lord, otherwise if the DP is.
No, because you see, there's a question which I have put many times in this courtroom. Number one, you'll have to demonstrate that he will suffer any prejudice.
Yes, my lord, that I can, my lord.
He can't. They
If
will,
lordship, I have given two things, my lord. The list of the witnesses that have been cited in the criminal case and in the.
that itself is not a ground for prejudice.
Well, appreciate, my lord, for a while. If the witnesses are same, if the documents relied upon are same, the Supreme Court is eloquently speaking, law, that of course it differs from fact to circumstance to circumstance. Lordship is there to protect my legitimate interest, my lord. Kindly appreciate the criminal proceeding is going at its good speed, my lord. We are not here to delay that process. The only worry of my friend is that if lordship stays the proceeding in the DP, I'll delaying the criminal case. No, it's 15 days they are getting date. And almost 10, 11 witnesses are being
No,
examined.
Mr. Sarma, this is not the query which I was having. My query is like this. You see, you have sufficient experience in trial. Correct? So with that viewpoint, I'm asking you a question. In a criminal trial, what are the materials on which the prosecution can rely? It is only the police papers.
Yeah, if it in my case, this in particular this case will not official reports.
So it's only police papers, whatever there in the case diary.
Yes,
In other words,
yes, yes.
police papers
Right.
means case diary.
Yes, sir.
Correct. Now, please tell me, in a departmental proceeding, supposing there's some evidence which is coming up in the departmental proceeding against you, can a APP introduce that in a criminal trial
No, my lord,
without declaring his own witness to be hostile?
no,
You
no,
see,
it's not that. It's not that. My lord, will appreciate my agony. My agony is this: the difficulties on my part is as a person to defend my case in the DP, departmental proceedings. It will be a disclosure of defense in that proceeding if it is allowed to go on.
correct.
And this will
That's why I'm asking you a
adversely-
question. Even if your defense is disclosed, can a APP bring it on record in a criminal trial? I'm asking you because you have some experience in trial court.
no,
You see, he can't bring in unless he declares his own witness to be hostile and put him questions. That is number one. Number two, APP will not have the records of a disciplinary proceeding so as to put questions to his own witness. That in this in the departmental proceeding, you see, I have all respect for the decision of Captain M. Paul Anthony.
yes.
With having noted its contents, I'm asking you this question. You see, the APP will not have a discretion of introducing the departmental proceeding papers in a criminal trial,
That is
except save and except for one provision in CRPC, which I can assure that most of the council will not know. I'm, with all respect to all of you, I'm
maybe Milord.
not demeaning anyone,
No, it may be.
but it's a challenge which I am throwing, that right now at this moment, nobody will be able to tell me the exact provision in CRPC by which a document which is otherwise not in the case diary can be introduced. That is a challenge only. Correct.
My
No, please let me complete so that you can give a comprehensive answer. But this is a question which is nagging me every time. Second part is, in a departmental proceeding, let us assume that you disclose your defense. And now, in a departmental proceeding, two things. Number one, does the departmental authority has the power to call for the records from Special Judge Assam and then putting questions?
no.
Answer would be no. Second is whether the departmental proceeding can travel beyond the show cause notice and the appendix 1 to 3, which has been given, containing the list of documents on which they rely. So if they can't, you'll have to explain me now. Now it is open to you. You please explain it to me. How do you suffer a prejudice,
No,
even if
Milord.
you disclose it?
Of course, what has come from your lordship is definitely a vital questions to for determining the issues. But at this moment, what I can or what I would like to impress upon your lordship is this: whether or not it will cause prejudice otherwise, if the Supreme Court says, my lord, if it is on the same set of facts and allegation, then it should not be allowed to go hand in hand.
But prejudice you'll have to show us.
Now the prejudice, how it will cause prejudice that will come into will come to know when the proceedings moves on. Now, well, it will be a thing like this, that you suffer first, then only will come to rescue. No, in my respectful submission, lordship will protect me from that sufferings, because it is not because the entire allegation is of that particular recruitment process, where allegation is that.
Second thing is that, you see, with your question, let me put the second question. Now you see, in a departmental proceeding, it is preponderance of evidence.
Yeah, preponderance of evidence.
And in criminal trial, it is strict
Beyond
proof of.
reasonable.
Now, let us take an extreme case. You are exonerated in the departmental proceeding. Will it lead to acquittal in a criminal trial? The answer would be no. And assuming that
Both
you
are
are
independent.
no,
of-
that's what
both
I'm asking you. You see, my question is on prejudice.
Yes.
I'm not an adversarial litigant now. I'm trying to understand, because
Yes, of course.
this is a question which is nagging me time and again. I'm Captain M. Paul Anthony, with all respect. I'm I'm being aware of the Supreme Court judgment, I'm asking you this question. The second part is, in a criminal trial, you are acquitted. So in a department proceeding, are you want to be exonerated? No. Again, the answer is no. So therefore, the question of prejudice, if I think, I don't find an answer.
Well, my respectful submission to this questions, Milord. The test of prejudice is not required if the law is flouted. That is also subtle proposition of law. If the test of prejudice is not required if the law is flouted. The subtle proposition is that if it is on the same sets of facts and allegations, same set of evidence, same persons as cited as witness in both the cases, then I believe in my respectful submission, my lord. But subject to your lordship says that,
Show me the authority with which you are relying.
that the test of prejudice is not required.
No, not test of prejudice, that you may not have. But the Captain M. Paul Anthony, please
Yes, yes, I have.
cited, let's say.
Paragraph 22. May I read?
Just one.
Paragraph 22.
Just one. (22).
Yes, ma'am.
Yes.
If I can read, Miller. The conclusion which are deducible from various decisions of this court referred to above are: departmental proceedings and proceedings in a criminal case can proceed simultaneously, as there is no bar in their being conducted simultaneously, though separately. If the departmental proceeding and the criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employee is of a grave nature, which involves complicated questions of law and fact, it would be desirable to say the departmental proceeding stay the departmental proceeding till the conclusion of the criminal case. Whether the nature of a charge in a criminal case is grave and whether complicated questions of fact and law are involved in that case will depend upon the nature of offense, the nature of the case launched against the employee on the basis of evidence and material collected against him during investigation or as reflected in the charge sheet. The factors mentioned at 2 and 3 above cannot be considered in isolation to stay the departmental proceeding, but due regards has to be given to the fact that departmental proceedings cannot be unduly delayed. If the criminal case does not proceed or its disposal is being unduly delayed, the departmental proceedings, even if they were stayed on account of pendency of the criminal case, can be resumed and proceeded which so as to conclude them at an early date, so that if the employee is found not guilty, his owner may be vindicated, and in case he is found guilty, the administration may get rid of him at the earliest. So, my lord, if they found at later stage that I am delaying the departmental proceeding, they have all the right to restart the proceeding by filing an IA.
I'll tell you what has changed. What has changed by now? You see, Asian roads resurfacing judgment has come. In the meantime, it's by a 3-judge bench. Now there it says, it has given an omnibus direction that even if any trial or any proceeding has been stayed by the High Court and it stays for 6 months without extension, then it will proceed.
Yes.
Therefore, the intention of the larger bench of the Supreme Court now is that no proceeding should be delayed.
Yes.
merely because the High Court is in session of the matter or Supreme Court is in session of the matter. So
If it is past 6 months, it will restart.
it will restart. So therefore, this is the change in circumstances which has happened from there to there. And in your charge sheet, how many witnesses are there in this case?
My lord, already 10 have been examined, my lord.
No, I'm not on that. How many witnesses are there?
I'm saying the last number, my lord. 183.
Then even if it is heard every 7 days, if the matter is distributed even after 7 days, look at the time which will take.
But it is moving at its good pace, my lord. The speed is very nice because in 3 months, they have examined, in 3 days, they have examined 10 witnesses.
No, that is okay, but it will cause delay. That is one of the factors which has to be considered.
My lord, if lordship does not allow me to have a stay order, my lord, then I believe
I'll issue a short notice. I'll give
Short
you 10
notice,
days time. In 10 days time, I'll issue a notice. We'll consider your prayer for interim.
but in the meantime, they will start it from Friday next. I'm told today morning that
Still-
the notice has been served on him to be appear,
Still, my lord,
to appear on.
let us say even my lord can stay, my lord. Let us file an affidavit, my lord.
No,
My lord,
don't
give us-
proceed for 10 days. For 10 days, don't proceed.
Yes.
I will inform them, my lord. My lord, may not, but I give my word, my
No,
lord.
no,
I will-
let
they have
it be
issued
recorded.
notice
These
to
things,
appear.
these things, let it be recorded because we don't want any, what you call, we don't want an unwanted situation.
Yes,
The reason is another, Mr. Dhar. If I don't record it and then something happens, it would be too bad for the court to issue a notice on the officer of the court and then see that this was there. So let it be postponed for 10 days. If you want, we'll give 7 days time. Don't do it till then. If it is on next Friday, we'll take it up on next Friday.
now coming tomorrow, today's.
My lord,
today's
may-
Wednesday, Friday.
Grant me
This
just 2 minutes time. I will just go and call up. Whether when they are starting it, if any date is
Friday
fixed, my
next
lord,
notice is there.
Huh.
I can just call up the secretary and I can find out my
You
lord.
will take it up after some time. You take your own time.
Well, you can show the notice, but it's not on print.
No, let him get instructions. Your notice and his instructions will have
Okay.
a lot of difference.
I'm waiting.
Item number 8 for admission.
Lordship, the matter has become infructuous, because the petitioner, he has got the promotion.
Oh,
Lordship,
He is seeking promotion to the next higher post of senior assistant. And he has been promoted.
Lordship, this is the second round of litigation. The first round of litigation, I have challenged the promotion of some junior who was junior to the petitioner from the date. I sought for promotion from the date the juniors were promoted, Lordship. But that was not done, Lordship. They promoted me in the year 2022 and the order which I was challenged, that was of 2016, Lordship. And the order is of 2019, the previous petition. Now they promoted me from 2022.
Then they have to make, he has to make the other respondents as private respondents as parties. Your Lordship. They are not a party to this whole process.
you're not party.
They were not, their promotion I have not challenged. In the first petition, their promotion I have challenged,
Your Lordship,
but their.
No, but you see, if you are promoted from your position after promotion
Lordship,
would be above them or below them.
no, without interfering their promotion, Lordship may kindly go through the annexure, Lordship. If necessary, they will be called for, but it is not that they will not be considered, Lordship. The order dated annexure 1/13/2019.
No.
your Lordship may also.
You see, you see your prayer.
Prayer.
Your prayer is that they will give notice to the case of promotion forthwith. But come to page 3. Page 3 in the matter of last 5 lines. To review the earlier order of promotion dated so and so by giving notice to those who have been appointed by the impugn order dated so and so before passing any adverse in the interest of so and so. Therefore, is the immediate case of the petitioner that somebody would be disturbed.
But that is for the authorities to issue notice to them in the event they consider the cases of the petitioner's lordship. Because first round they never appeared lordship. So I have served copies to them through the respondent number 3. And after that also no one appears lordship. So it is for the authorities to issue notice to them in the event
Mr. Sharma, you see, the anxiety of the court is that the order of the court must be compliable order. Correct.
lordship.
Now, if I issue a direction to consider a case for promotion,
Lordship.
I'll have to be very sure as to who are affected, because you see, let us assume that X will be affected. He'll accuse the court of not hearing him before this order is passed for reconsideration.
In that case, I may be allowed to implead them lordship. Lordship. I will file a IL.
Okay. Okay. Ms. B. Sharma on counsel for the petitioner. Mr. D. Borar, the government advocate, has produced a copy of instructions dated 6/12/2022, issued by the Undersecretary to the Government of Assam, Sports and Youth Welfare Department, indicating that the petitioner was promoted to the post of senior assistant during the pendency of this writ petition. Full stop. Next paragraph. In the said context, the learned counsel for the petitioner has submitted that in this writ petition, the petitioner has challenged the promotion order dated 29/2/2016. Accordingly, it is submitted that the promotion made to the petitioner by the subsequent promotion made to the petitioner would in no way affect the challenge made in this writ petition. Stop. Next paragraph. In view of the prayer made by the learned counsel for the petitioner, the submission made by the learned counsel for the petitioner, the learned government advocate has pointed out that the parties who would be affected by this, by orders passed in the writ petition are not are not aided as respondents. Stop. Next paragraph. The learned counsel for the petitioner prays for some time to obtain instructions and to file appropriate application if so advised. Full stop. Matter stands adjourned today, list after
3 weeks.
Yeah, after 3 weeks. I'm giving you back the police.
Yes.
The instructions produced by the government advocate is returned.
Of life.
In the meantime, you file an affidavit, bring it on record. The
Yes,
promotion
sir.
made.
Yes,
Otherwise, we'll have difficulty in.
that is what.
9.
Yeah, your loss. In this document, the opponent has not filed any affidavit. Lordship, instruction received, Lordship. Dada. The instruction received, Lordship. Whereas it is categorically stated, Lordship, from the CCTV footage, Lordship, it appears that the physical efficiency test for the long jump, Lordship, appeared by the petitioner on 16/11/2021, Lordship, has been analyzed thoroughly. And after analysis of the CCTV footage, it appears that the petitioner was given 3 times chances Sanchez to clear the prescribed distance, but he failed. My lord, page 35.
35.
35. See, instruction is contrary to this lordship. Exact only.
Yes, 35.
35 lordship. Lordship and physical eligibility test, long jump meeting in the last lot, past length covered 0. Yes. Second length 4.23. Third length 0.00. That means he has not given lordship three times chance. Lordship as per the advertisement lordship, and the highest length covered lordship they have taken lordship 4.23 lordship. And as per
You see,
the
that was second.
lordship.
See, in the first length, you see, if in the first time is the resolution said that he jumped 0, we don't know whether he was there or not, but but you see the jump, the result is not in first. First is 0, it is second, it is shown as 4.23. So it is not acceptable that you were not given the first chance. You may have jumped, you may not have jumped, or in a long jump, if you cross the start mark,
Yes.
then the results are negated.
Yes.
You get 0 when you jump, even if you jump 10 meters after that, when you cross the starting line, you don't get a mark,
Foul jump.
a foul jump, right? You reminded me of these sports after 45 years.
In the school days.
Full time.
School days.
It's just like no ball in cricket.
Yes.
There's a CCTV footage you want we can, the authorities can show it to him.
Yes.
And you see, there are more information here. They have analyzed the CCTV footage. It says that CCTV footage clearly visualizes that the petitioner, Azharul Islam Laskar, was before making run for long jump, he was limping, which insinuates that the petitioner had some injury in the leg before appearing for long jump event. And they have no record that you were called on the next date for long jump. You file an affidavit because the petitioner was no where he stands. Both sides are duly represented. Mr. J.K. Goswami, the government advocate, has submitted that he has received Paraguay's comments and prays for his granted 2 weeks time to file affidavit in opposition in the matter. List after, you make it 3 weeks, within 2 weeks you file, list after 3 weeks.
Then item number 10.
We have filed the affidavit in this matter, but they have not yet filed any rejoinder to that.
Okay, none appears on call for the petitioner. Mr. D. Boraran, you are appearing as CGC here?
No.
The government advocate.
Government.
Okay. The government advocate has submitted that affidavit in opposition has been filed on 23/5/2022. First up, for answer justice, the matter is adjourned today. List after 2 weeks.
11.
In this matter, affidavit has been filed, man, last occasion. And my lord, I need 7 days time to file a reply is required, my lord, regarding, although it is a compassionate appointment, and prayer was rejected on the ground of financial condition, which is to be, my lord, verified, my lord. In my record, my lord, the father of the petitioner received the retirement, death cum retirement benefit amounting to 14 lakhs something. They have stated that, my lord, it is more than 21 lakhs. And I am receiving the pension, my lord, only now it is 17,000, about 18,000. My mother is receiving, my lord. And on this count, they have said that I am not entitled. And I have to file reply on this matter.
You want to file a reply?
Yes, ma'am.
Okay. And the prayer made by Mr. has not counsel for the petitioner. List after,
7 days or 10 days.
list after, we'll make it 2 weeks, list after 2 weeks, so as to enable him
weeks,
to
yes.
file affidavit and reply in the matter.
Plus,
Well, my lord.
Yes, Mr.
my lord,
Hussain.
I have to file reply, my lord. Respondent
Reply.
filed already affidavit in opposition, my lord.
Okay, how much time?
My lord, 4 weeks time.
Okay, I have 4 weeks for you. Both sides are represented. Mr. A. Hussain
Yes.
for the petitioner. This one granted 4 weeks time. In the final matter.
August. 14.
May I please your lordship? Lordship, in this matter, for respondent number 2, 3, 4, and 17, lordship, senior counsel Mr. P.K. Tiwari will appear. We are going to file wakalat number, lordship. Lordship, may grant kindly 2 weeks time for file the wakalat number, lordship.
Along with Vakalat, you file your affidavit also.
Yes, lordship.
How much time?
2 weeks time, lordship.
2 weeks.
Lordship.
Okay. Both sides are represented. Learned counsel for respondent numbers
2, 3, 4, and 17, lordship.
2, 3, 4, and 17. Praise for him is granted 2 weeks time to file affidavit in opposition and Vakalatnama in the matter. List after 2 weeks.
Obliged, lordship.
Well, what about service on others? Is it complete? Service on others, is it complete?
Yes, sir. Lordship, we need 3 weeks time to file affidavit in reply. And private respondent is yet to file affidavit.
You have filed your affidavit.
No, Lordship, we need 3 weeks time
You need 3 weeks time.
to reply affidavit.
Okay. In terms of order dated 1/6/2022, the Learned counsel of the petitioner 3 weeks for the time to file affidavit in the matter.
Lordship, private respondent is yet to file their affidavit. Respondent. have
It's
filed-
okay if they don't file, good for you. Good for you. One competition is less. Why are you worrying? Government advocate is present. Let's start.
Hey, lordship, pleadings are
16.
completed otherwise.
May I read the lordship? Lordship.
Yes.
Pleadings completed, lordship. Pleadings are completed, lordship. Oh.
Lordship, I fix it for any motion, admission day hearing.
No, this is only a question of distance. Only one factor is there.
One factor.
Shows that distance, how you have shown that the distance is within that area of operation.
Lordship, in this case, lordship, earlier they are engaged, lordship, at 258 Horinagar Park 3, Tukergam, within bracket Tukergam, lordship. It is locally known as Tukergam, lordship. And this Tukergam is far away from this area, center area, Lordship. And it is, Lordship, in the midst of 2012, Lordship, on verbal instruction, Lordship, they work here, Lordship, and Tukergam, Lordship. And thereafter, Lordship, 2 order was passed, Lordship, at page 30-34, Lordship, by the CDP also, Lordship, earlier former CDP, Lordship, and on the basis of inquiry report, Lordship. At page at page 30, Lordship, it is issued by the CDP, Lordship. May I read it, Lordship?
Just tell me what it is.
In
Don't read
public
that.
interest, Lordship, you are directed to render voluntary services Anganwadi worker at center number 258, Harinagar Part 3, Anganwadi Center, to the specified area as demarcated the functioning service area of the said center number 258 by Harinagar GP, where you have been rendering voluntary service as Anganwadi worker since the date of joining. Lordship, I have joined in this center, Lordship. And Lordship, and thereafter, Lordship, another order is, Lordship, at page 34, Lordship.
Yes.
It is also issued by the IC CDPL, Lordship. In the interest of public service, Srimati Farhana Begum Bodobuya, AWC number 258, Harinagar Part 3, Tukergam Village, Harinagar 3, Revenue Village Katigora ICDS project is hereby directed to continue her duty at the aforesaid Anganwadi Center as per appointment order, where it was sanctioned until further order. This is reference to the certificate from CO Katigora by number KCC, that's one, so, Lordship. Lordship, this circle officer's report is, Lordship, at page 33, Lordship.
Just a moment. Page 30.
33, Lordship. Is to be certified in the light of inquiry report as well as on the basis of records that Tukergam and Harinagar Part 3 are 2 separate revenue villages, Mauja, bordering each other under Haritikar Pargana in the Katigora revenue circle area, wherein a part of revenue village Harinagar Part 3 is locally known as Tukergam. And the said revenue village Harinagar Part 3 is bounded by river Barak on the south, Haritikar Part 2, Harinagar Part 2 on the north, river Surma on the west and Harinagar Part 2 on the east. It is the circular officer report, Lordship. This Tukergam, within bracket Tukergam, in the engagement letter.
You see, in the affidavit in opposition, they have said that despite several directions to you, you did not join the duty. So, if you did not join it, then why should you interfere?
I have been rendering my service, Lordship, from since the date of joining, Lordship.
No, you did not join. You're not found. You are found absent in duty, and therefore your honorarium was stopped.
Lordship, on the basis of these two orders, Lordship, I worked in my original place, Lordship. It is far away from my central, Lordship, and on several approach, Lordship, the authority, Lordship, did not allow me.
But once you are not working, why should we encourage you? They have said in affidavit that you are not working. Despite orders,
in my original area, Lordship. In my original area, Lordship, which is, Lordship, I also submitted one additional affidavit, Lordship. Whereby, Lordship, can you see at page number? Page number, Lordship. 51, Lordship. Yeah, Lordship, the Goptam Assam, Lordship, recently, Lordship, took a plan, Lordship, to, here, Lordship, I have mentioned in the para 2, Lordship. The Government Assam recently expressed their view that the new education policy would link Anganwadi centers with nearest primary schools in the near future, where the education where the Education and Social Welfare Department would prepare a plan jointly in order to provide special importance for nutritional as well as intellectual development to the children. However, pursuant to the government direction, the headmaster of 1617 number Dakin Harinagar LP School made a visit to the petitioner Anganwadi Center, this center number 258 Harinagar Part 3, Lordship, Tukerga Angana Center, on last so and so, in order to submit status report of the petitioner Anganwadi Center. Lordship, I have annexed this copy, Lordship. Lordship, at page 54 is the and 53 is the type copy, Lordship. Here, Lordship, Harinagar Part 3 is mentioned, Lordship, in the column, the name of Anganwadi Center, Lordship. So, from the very beginning, my center is, Lordship, within that area, Lordship, it is my locality, Lordship, and it is one of the condition, Lordship, for the notification was issued, Lordship, for advertisement, Lordship. I have also annexed the notification, Lordship, in the page 57, Lordship, in my reply, Lordship. One of the precondition is that, Lordship, the candidate for the post of AWD, AWA shall be a local woman residing in the villages, locally covered by the concerned Anganwadi Center. It is, Lordship, the mandatory requirements of and qualification of, Lordship, eligibility criteria. And, Lordship, another is, Lordship, at page 58, Lordship. The candidate shall submit applications in the office of the CDPO concerned by register.
Where is your appointment order?
Lordship,
Where is your appointment order?
appointment order is, Lordship, at page 1920, Lordship.
Page
19, Lordship, and 20. Lordship.
19.
19 is for Anganwadi worker. Nineteen is for Anganwadi worker, Lordship. Here, Lordship, render voluntary services Anganwadi worker at center number 258 Harinagar Part 3 within bracket Tukergram. This Tukergram is locally known as Tukergram, so it is mentioned at Tukergram, Lordship, because within that area also 3 other centers also, Lordship, they are, Lordship. So it is mentioned Tukergram as known by the local people, Lordship. And another is, Lordship, page 22 is for helper. 20 at page 20, Lordship. In page 58, Lordship, the candidate shall submit application in the office of CDPO concerned by registered post or in person giving following information. And the information is, Lordship, at number 9, Lordship, the name of the AWC for which apply. At that time, Lordship,
This in your affidavit, there is no clarity. The petitioner joined at Harinagar Part 3.
yes, Lordship.
So why should the petitioners do duty in Tukaram LP school?
Lordship, I have to go by the affidavit also only, your Lordship, here,
But there is no reason assigned. Why a person appointed there will work at Tukaram LP school?
Otherwise, if your Lordship peruses to paragraph number 2 of the affidavit, in the year 2012, 11/9/2012, a general meeting headed by the ward member named Shri Monoranjan Das was held on to 810 Tukagram LP school. And unanimously in the meeting, the resolution was taken that above mentioned AWC should run at 810. That was the decision most probably in that meeting. That is
No,
why.
but this is not clarity of which center would run from where. And number 2, the Anganwadi centers are designated by the Director of Social Welfare. So can somebody take a meeting and say that no, from today the center of say let us say Amingaon will run in the Guwahati High Court campus?
But here at paragraph, second paragraph, accordingly, the said AWC Anganwadi Center was run in Tukagram village located in an Indo-Bangla border. The above mentioned AWB, AWW and helper, namely so and so, did their duty smoothly up to 30 2019. But from 1/4/2019, both AW and AWH were absent from the duties. So from then, they were not paid their honorarium because they did not uh, turn up for the duties. And that is a fact that which has been established in terms of the affidavit.
No, no,
And the
you
prayer
just-
also.
You say, first thing you have not said that it is the same center which has been relocated there. So if it is relocated there, if it is not relocated, why should you work in some different center?
Lordship, let me get some clarity as to whether they are the same center or not.
Lordship,
If
may I
it
supplement
is the
on
same
this?
center,
Lordship, we took this duty, Lordship, additional duty, Lordship. It is, Lordship, at page, kindly see at page 27, Lordship, which my learned had already mentioned, Lordship. At page 27, Lordship, which is written Bengali, in Bengali, Lordship, in the middle portion, Lordship. And this order was not written order, Lordship, where I took my duty, Lordship. In the middle portion, Lordship, সেই এলাকার সাময়িকভাবে সপ্তাহে একদিন অতিরিক্তভাবে 258 নং কেন্দ্রের ওয়ার্কার ও হেল্পারদেরকে কাজ চালানোর জন্য বলেন। এডব্লিউসি এমসি গঠন করতে বলেন, মৌখিকভাবে অনুরোধ করে বলেন। So Lordship, I took this duty as an additional work, Lordship. And no written order was there, Lordship. And subsequently, the two written order was passed, Lordship, on the basis of inquiry.
Let him get that.
Because Lordship, sometimes
Sure.
the CDPO join, one CDPO join and one CDPO release this area, Lordship, from their duty, Lordship,
No
and
problem.
transfer another place, Lordship. And that is why the
The learned
Lordship-
counsel for the petitioner has referred to the appointment orders of the petitioners at annexure C and D of the writ petition. The project that the petitioners were appointed in as Anganwadi worker oblique helper at 258 number Harinagar, HARI, NAGAR, Part 3 Anganwadi Center. Within bracket, Tukergram, TUKERGRAM. By referring to the copy of proceedings dated 11/9/2012. Within bracket, annexure E to the writ petition. It is projected that the petitioner was given additional charge to visit, to do duty at
revenue village to Kerala.
at where?
Revenue village to Kerala.
At Revenue Village, Tukergram. To run a center at Revenue Village, Tukergram. Accordingly, it is submitted that as there was no formal order to appoint the petitioner as Anganwadi worker oblique petitioners as Anganwadi worker oblique helper at Anganwadi Center in Tukergram village. No adverse orders to the interest could have been passed. Full stop. Next, it is noted that in the affidavit in opposition filed by respondent number 5, there is no clarity as to whether the number 258 Harinagar Part 3 Anganwadi Center was relocated at Tukergram Tukergram LP School, comma, the respondent numbers 1 to 5. No, 1, 2, 4, 5, and 6. They'll file an affidavit to clarify as to whether the Anganwadi center where the petitioners were appointed has been relocated at another site. And also as to whether the petitioner was given additional charge, petitioners were given additional charge for the second Anganwadi center located at, no, not second, they get another Anganwadi center being run at Tukergram village. Next paragraph. The learned government advocate shall transmit a downloaded copy of this order to the respondents. This after
3 weeks, Your Lordship.
3 weeks.
And fix a date.
You make a mention if it is not listed. Make a mention if it is not listed.
Item number 18, we have not yet received any instructions with regard.
May I please, my lord, her lordship will find, my lord, the impugned, my lord, select list at page 32. my lord.
But the affidavit will be required.
Serial number 2.
That's what you like.
Now, so
How
for
much?
respondent
But
number
they're taking
5,
too much of time, 22,
I
1
understand.
year.
Your Lordship. We have written to them so many times, but.
We'll ask the authorities to be here, otherwise they will not, they are not
Your
interested.
Lordship may grant him just one last opportunity, Your Lordship. If not, then personal appearance may call for Your Lordship.
Okay. Both sides are duly represented. Notice of motion was issued in this matter by order dated 8/8/2022, and for more than a year. The respondent authorities could not find time to file their affidavit in opposition in the matter. Next, the court was inclined to call for the personal appearance of the respondents. So, however, on the prayer made by Mr. D. Barra, London Government Advocate, the order for personal appearance of the respondents is deferred, by providing that in the event affidavit in opposition is not filed by the respondent authorities within within 29/8/2023, appropriate orders will be passed on the next date. To direct the respondent authorities, number 1 to 4, to be personally present with all relevant records, so as to assist the government advocate. For personal appearance will be passed on the next date. Next, by the learned government advocate shall send a downloaded copy of this order to the respondent number 1 and 2. Next, for this one, 3/08/2023.
Good progress. Highly appreciated.
19.
Lordship,
Yes,
I beg apology, Lordship. On item number 62, there is a bail hearing was there, Lordship.
yes.
I have gone through the record. Everything was of 2021, Lordship. So up to date is not arrived, Lordship. And for some personal difficulties, I will be also not present in the second half, Lordship. So let the matter be fixed. on
Okay,
some
let the lawyer be.
Lordship.
Okay, I'll pass orders. You are there?
Oh, Lordship.
No,
Lordship.
you are there.
item number 19.
Oh, no.
Lordship. That was afterwards, Lordship, before I.
Okay, just give a slip to the court master.
Lordship,
Give
Lordship,
a-
I beg the apology.
Please, okay, you give a slip to the court master, adjourn the matter. Item 19, yes.
My lord, matter pertains to compassionate appointment, my lord. The district level committee has recommended the name of the petitioner and accordingly placed before the state level committee. And the state level committee.
But your service was a pensionable service.
My
You are getting the pension,
Yes, sir.
then will you be entitled to compassionate appointment?
Yes, your lord. Lord, due to overage, my lord, due to overage, the state level committee has rejected.
No, I'm asking you, if there is a pensionable service, will you be entitled to
Compassionate appointment.
compassionate appointment?
I think in every compassionate appointment, there is a family pension, your lordship. Yes, your lordship. It's entitled. Page 28, your lordship. Minutes of the state level selection committee, your lordship, held on 5 January 22, your lordship. By the committee, it is held that due to overage of the petitioner, the case of the petitioner could not be considered. And there is provision for relaxation of upper age limit, your lordship.
Where is that?
Yes. Page 36, your lordship.
33.
What is memorandum, your lordship? Page 36, clause 16, your lordship. The upper age limit would be relaxed wherever found to be necessary as per the existing government policy. The lower age limit shall, however, no case be relaxed below 18 years. As eligibility shall be determined with reference to the date of application and not on the date of appointment. The state level committee shall be solidly competent to grant relaxation of upper age limit for making such appointment as per existing government policy. After rejection by the state level committee, my lord, one application has been submitted before the state level committee with a prayer for relaxation of overage. My limited prayer is that, my lord, that the government be directed to dispose of the application for relaxation of overage of the petitioner and place the matter again before the state level committee for fresh consideration.
Yes.
Lordship, also there is a provision for relaxation, but at the same time in the petition, Lordship, it is the petitioner had not stated these 7 years how she maintained or whether she is suffering. Lord, that was not mentioned in the petition. Lordship.
My lord, page 8, your lordship, para number 9, my lord. Not
No,
7 years, my lord, 2
the
years.
answer is very simple. She was getting a pension, she did not suffer.
Yes.
But if your policy admits compassionate appointment to people who are getting what you call pension, then why she would explain that she is suffering?
It is not the right, Lordship. The compassionate appointment is not the right, Lordship. It is the.
No, you see, you have a policy.
Yes, Lordship. Yes.
Right of consideration is there, always there. You can't say that
Consideration.
there is no right. Right to be considered is your policy.
Lordship, it may be said.
Then what happens if your chief secretary does not read, he's the head of the state level committee. What happens if he does not read clause 15, sorry, 16 of the policy? That is the only thing he requires to be done. He is required to examine.
Lordship, 16, Lordship. Yes, Lordship, 16 is there, Lordship, but at the same time, Lordship, 16.
At the time of application, my lord, she was as at about 42 years.
Application, yes, application
She was
was,
42 years.
yes, application was,
In
Lordship,
2 years.
application was in 2018, Lordship.
Then it is dereliction of duty by the chief secretary. And that would be very serious. To issue a notice to the chief secretary to show cause why there was a dereliction of duty in not reading the clause 16.
So, limit could be relaxed, Lordship. That is the language, but the 16 clause 16 could be relaxed. Lordship.
Correct. So in the order, he should say, I don't relax it.
Yes, yes.
And
No,
the
it
question
will
of
be-
relaxation will not even come if he's 42 at that time. That means the chief secretary did not read it.
It may be interference.
No, but how will the court expect the chief secretary to, you see, with,
The explanation is not there.
no, not even that.
Yes.
The condition is that her age at the time of application should be considered. So if your chief secretary doesn't read the clause, how is he running the state administration? We'll set this aside and send it back. Well, Mr. A. Rahman, counsel for the petitioner. As well as Mr. J.K. Goswami, government advocate appearing for respondent numbers.
Lordship, one,
Additional senior government advocate appearing for
2 and 3,
respondent numbers
Lordship.
2 and 3.
Yes.
And Mr. R. Gogoi, and standing counsel for excise department appearing
1
for
and
respondent number 1.
1 and 4.
1 and 4. Next paragraph. Agreed by the SLC decision taken taken in the minutes of the meeting held on 5/1/2022. Thereby rejecting the application of the petitioner for appointment on compassionate ground on the ground due to overage of the petitioner at the time of application is assailed in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. Where is your application for compassionate appointment?
I have not annexed the Lordship.
Application is not done.
And how do I know that you were, what is your age at that time?
Application was on 7/9/2018, Lordship.
No, it's okay,
Applied-
but on that day, what was the age? How do I know that now?
I have annexed on admit the Lordship. Date of birth is recorded the Lordship.
No, those things won't do.
Page 30, your Lordship.
Those things won't do. What is the date given in the application would be material because I would be, what do you call, making remarks against the chief secretary. I can't do that if you're not annexed the document itself. Is the recommendation by the authorities there? Anything where I can know the age?
Is 18, your lordship.
Page,
Page 18. At the bottom, my lord, the superintendent of access Karimganj forwarded claim of Srimati Saitali Das. This is the petitioner, your lordship. Wife of late sub Das. Ex-head constable, care of censor, censor, and
no, here the age is not given.
it's not given.
Your declaration of age.
From the admit card, the age was given, and if we calculated the date of application, then it is comes 42 at the time of application.
Page 30 is the admit card.
Page
30 is
30.
the admit card.
30,
30 is the admit card.
30.
Yes.
Yeah, just a minute.
25/7/1976.
The next, the case of the petitioner is that her husband was serving as who at the relevant time was serving as excise constable, died in harness on 12/9/2016, leaving behind the petitioner and one son. Full stop. The petitioner applied for appointment on compassionate ground, and the DLC Karimganj, in its meeting held on 4/3/2019, recommended the name of the petitioner for appointment as excise constable on compassionate ground. Full stop. The petitioner projects that by referring to the birth admit card within bracket annexure 5, the Learned Counsel for the petitioner projects that the petitioner was born on 25/7/1976. And as per next of kin certificate within bracket annexure 2, dated 30/11/2016, the age of the petitioner is depicted as 40 years. According 80 years So accordingly submitted that on the date of applying for appointment on compassionate ground, the petitioner was 42 years of age. Full stop. Next paragraph. The recommendation of the DLC in respect of the petitioner was placed before the state level committee within bracket SLC for short. And the SLC on compassionate appointment in its meeting held on 5/1/2022 rejected the candidature of the petitioner on the ground that the same could not be considered by the committee due to overage at the time of application. Next paragraph. The learned counsel for the petitioner has referred to the office memorandum dated 1/6/2015 relating to appointment on compassionate ground and has specifically referred to clause 16 of the said OM, which reads as follows, page 36. Next paragraph. So accordingly, it is submitted that the state level committee was represented by, was headed by the chief secretary, did not take adequate care to examine clause 16 of the OM dated 1/6/2015, which requires that the age at the time of application should be considered and not the date of appointment, and that the state level committee had the competence to relax the upper age for making such appointment. Full stop. Next paragraph. The learned government advocate, additional senior government advocate, has justified the rejection of the candidature of the petitioner on the ground that as per the policy, although there was power to relax the upper age, but it is not mandatory that the said exercise should be undertaken, should always be undertaken. What did you say? That it's not required to be undertaken. And what is the second ground?
Lordship, the relaxation, the provision for relaxation is there, Lordship, but it depends to the committee, Lordship.
So, and it is at the discretion of the committee. Sorry, SLC. Next paragraph. The stand of the learned additional senior government advocate is not found acceptable for the simple reason that if that as per clause 16 of the OM dated 1/6/2015, the requirement to consider the age was referable to the date of application and not the date of appointment. Full stop. As per the admit card of Board of Secondary Education Assam, within bracket Annexure 5, discloses the birth date of petitioner as 25/7/1976, and the next of kin certificate within bracket Annexure 2 discloses the age of the petitioner to be 40 years as on 30/11/2016. Comma, the court does not find the age of the petitioner to exceed the maximum employment age what is the employment age, the maximum employment age? 38.
38 is in the normal course, one-time measures, it was given 45 lakhs.
Maximum is 50.
No.
50 for disabled candidates.
No, she's not disabled.
Yes.
For a healthy person,
38 is there. Lordship.
Now it has been increased to 40 for grade 3 and grade 4.
40.
40.
40 for one-time measures. Nothing.
No, they don't have that. So therefore, in terms of clause 16 of the OM dated 1/6/2015, the SLC had the power and competence to grant relaxation of upper age. To stop the said exercise was not made by the SLC while taking a decision. In its meeting held on 5/1/2022. To stop. According to the court, is inclined to set aside the minutes of the SLC held on 5/1/2022 within bracket Annexure 4, insofar as it relates to appointment in the excise department on compassionate ground in respect of the petitioner, namely Srimati Chaitali, CHAITALI Das. The SLC is directed to take note of clause 16 of the OM dated 1/6/2015, as it has the competence to grant relaxation of upper age limit for making appointment on compassionate ground as per existing government policy, the SLC shall take an appropriate decision in the matter of relaxation of for considering the relaxation of upper age of the petitioner for making appointment as per existing government policy, and pass a fresh order after reconsidering the candidature of the petitioner in light of clause 16 of the OM dated 1/6/2015. Next one. The fresh exercise to reconsider the application of the petitioner for appointment on compassionate ground shall be taken up by the SLC, preferably within a period of 3 months. Within a period of 3 months from the date of receipt of certified copy of the order. There's a service of certified copy of the order in the office of the where?
Respond number 2 allowed.
Respond number?
2.
Sorry,
SLC.
Huh?
Respond number 2, yeah, 2.
Respond number. Certified copy of the on respondent number 2, I, the state level committee. Too slow. The question says not to the extent of indicated above.
Much obliged. Highly obliged.
We can come back.
Not in my copy, the last date is mentioned. Yes. So, my lord, I may be permitted to place the full copy of the advertisement, proper legible copy, and full copy of the advertisement. Because my copy is at page 41, my affidavit. And the very point that I wanted to emphasize that I find is cut off.
He applied on 12/2.
Yes, he applied on 12/2, and the last date was on 15/2.
15.
15/2, 15/2/2022 months.
Then
Look, if he admits that that is the last date, I have no difficulty. Then we can proceed, my lord, on the point of law. The short question is whether my lord, he attained the higher qualification on that date or not. If he did, my lord, then his candidature cannot be considered. That is the point. If he
Because-
admits that is the last.
Because even if it is 15, let us assume that it is 15.
Yes.
But on 15th, he got the higher
Yes,
qualification.
yes. And the law, as a lordship is aware, if on the last date of submission of applications, he attains the higher qualification, then also he will be disqualified. That is the difficulty. Then also he'll be disqualified because the maximum eligibility was of 12th pass. She became rather a graduate on that date. On 15/2. So graduates are not eligible for this post. This is the post of peon, only for the class 12 pass. So that's if we can proceed on that.
It is correct that date of last date of submission is not mentioned in my advertisement also. I could not get that full evidence in his affidavit also it's not there. But that's it. I'm not admitting that it's 15/2 is the last date. In terms of their this affidavit, I'm just relying on that only. The 15/2 is that in February 22.
You can let him bring out.
Yes, yes.
Let it be on. Let it be brought on
Let's
the record.
follow sake of argument, lordship. I would like to bring a lordship letter through the advertisement also. In the advertisement, in the eligibility criteria, it is clearly stated,
Page
page 15 of my petition lords.
15.
15, 1/5.
Yes.
The serial number 5, eligibility. What's it got it?
Yes.
Yes, it's categorically stated educational qualification and is on 1/1/22. So, and on 1/1/22, I was not a graduate lordship, and I submitted my application lordship on 12/2/22. Whereas it is on 15/2 only I was qualified. I was declared to be a graduate lordship. So let's see, when it is clearly stated that eligibility educational qualification and is on 1/1/22 should not be more than higher secondary. So I was not a graduate on 1/1/22, which they have admitted also, and which the records also reveals.
That is not disputed. Yes, but as on the last date,
But
she became a
yes,
graduate.
no, is correct.
Bring it on record.
Yes,
Yeah, it is meant. Mr. Kayivita has a point.
one post is already, another post is a vacant post.
Both sides are duly represented. Mr. Anganwadi, let it. Counsel for the respondents.
1, 2, 3.
1, 2, and 3.
Episode 4 year.
Place for. And it's granted. How much time? 10 days?
A week's time.
A week's time to file additional affidavit to bring on record. The last date of
Submission of the applications. The last date for submission of
last date of
applications.
submission of documents on record. Counsel for respondent who is present. List on, give a date after a week.
of August, 25/8.
25 has some difficulty. And 25 in the next
28.
20.
August then.
Can it be 29%?
No, not 29. 30 then. 30.
30. No, oblige.
Item 21.
Yes. Your Lordship, we have not received any instruction. They have not served us any extra copy also. Not served. Okay, there's no representation from the petitioner. Mr. D. Baral, and government advocate. And Mr. J. Hendrik, study counsel for the revenue department.
1 and 2.
Submitted that extra copies of the petition has not been served on them. For which they are unable to obtain instructions. First. Requisite extra copies of the petition. He served on the government advocate and the departmental counsel. Within 3 days. Subject to copies being served. List after 5 weeks to enable the learner government advocate and government department counsel to obtain instructions. 5 weeks.
When 22.
Let's just pass over the matter for 10 days.
Finding.
23.
Your Lordship, in this matter, we would like to file a affidavit in reply. Here, in 23. They file a affidavit in opposition. Interim order is there. Okay, what's such a representation? Mr. D. Bora, counsel for the petitioner. Case for is granted. How much time? 3 weeks time. 3 weeks time to file affidavit in reply in the matter. Mr. C. Burwell.
For 5 and 6 filer.
Standing counsel for responding to 5 and 6.
5 and 6.
This chapter 3 weeks. Obliged. Interim order may continue. Interim order constantly stands extended to the Wednesday of this day. Obliged.
May it please your Lordship. Lordship, the petitioner is working as an Anganwadi worker, my lord, in Pahukatha Anganwadi Center, my lord, for 2.5 years, my lord. 2 years, 4 months, my lord. My lord, she was selected and she was, my lord, removed from the post for slightly overage, my lord. She was rejected on the ground of overage, my lord. My lord, may peruse the interim order, my lord, 7/12/2022, my lord. I am in interim, my lord. My lord, in their affidavit, respondent number 4 affidavit, my lord, and it is in page number 14, my lord.
Just.
My lord, may be clear by reading this.
No, there's a last order of this code of 10/8. You are required to file a
My lord,
affidavit to produce the his
my lord,
certificate.
my lord, my lord, I am not able to contact the client, my lord. She is not well. She'll come within a week, my lord.
We'll have to adjourn it.
My lord, the matter, my lord, on the last day, just she wasn't given an opportunity to produce the age certificate to prove her age. But that age is never disputed, my lord. Even in her affidavit and in the documents before the recruitment authority, my lord, her age is above 44. My lord, if my lord peruses the affidavit as well in the writ petition, she writes it's 45. The affidavit at page, my lord, page 10, my lord. She's aged about 45 years. She has not disputed that.
This, in my copy, is corrected to 44.
Oh, my lord. My lord, in my copy, my lord, it was served as 45. In any case, my lord, she has not disputed that her age is above 44. She admits her age is above 44. In the my lord, the CDPO's affidavit, her age is given as 44 years, 11 months, as on the date of the consideration. My lord, here the question, my lord, she has premised her writ petition on the ground that she was working for 2 years prior to the advertisement, and therefore she needs to be considered for the post, my lord. But my lord, this fact is incorrect, my lord, as adduced by the CDPO in his affidavit and as well as from her own statements. On the last date, my lord, I had given a copy of one note which I had prepared, giving the dates, the periods of the monthly reports which she had submitted. If that is available, my lord, in the file, my lord.
My lord, I have certain documents regarding that she has been working for 2.5 years, my lord, that I can produce in the next date, my lord.
My lord, another copy. I'll read from her own documents, my
She
lord.
has been working from 2019, my lord, that I can produce certain documents regarding that. She has been already working for.
Why the condition of, why fresh application was required?
She was never appointed, my lord. My lord, this note, my lord, from her.
Let him complete, then you.
My lord, if my lord comes to page 13 of her of the writ petition, my lord, that is the English translation. Assamese version is page 20 to 27. This all the monthly reports she has clubbed together as annexure 1, annexure A. But my lord, if my lord comes to page 13, it's the English translation. Here, my lord, the third row from bottom, my lord, Anganwadi worker. The name is given as Sri Hiranya Devi Bora, the petition. Now, my lord, may come to page 20 to 27 is the Assamese version of this. Then again, page 28. This is for the period, my lord, 1/3/22 to 31/3/22. My lord, third line from, third row from bottom of the table, my lord. Anganwadi Kormi, Sri Hiranya Devi Bora, the petitioner. The period here is important, my lord, 1/3/22 to 31/3/22. Then, my lord, page 30. This is a continuation from page 28 to 29. Then page 30, my lord. There is no period mentioned. Why I'm pointing out, my lord, because the CDP has stated that she on her own has taken away these documents. But there is no period mentioned here. But her name is given in the second last row of the table, Hiranya Devi Bora. No period mentioned. From page 30 to 33 is this report. Then page 34, my lord, may kindly come. 34, my lord, may kindly see the period, my lord. 1st September to 30th September at the top. Then third line from bottom, Anganwadi Kormi, Sri Mon Bora. And not the petitioner, my lord. The person in who was actually the Anganwadi worker up to December 2021. Sri Mon Bora, and my lord will find the date, because the period, only the day and month is mentioned in this page 34. My lord will find the date at page 41. The report continues up to page 41. Down below at the signature stage, my lord. Anganwadi Kormir naam Mona Bora, Gaor naam Pohukota, code so and so, March, September, Bosor 2021. So from 1st September 21 to 30th September 21, the Anganwadi worker is Mon Bora. It's her own document, my lord. Then next page, my lord. Page 42, my lord. Again, this period is 1st October 2021. This is given in the first page itself, page 42. 1/10/2021 to 31/10/2021. Anganwadi Kormi, Sri Mon Bora. Third row from the bottom. Then monthly report from 1/12. This is at page 50, my lord. Page 50, 1/12/2021 to 31/12/2021. Third row from the bottom, petitioner's name is recorded. Well, the reason why? Because Mon Bora, she died on 20th of December 2021, as stated by the CDPO in his affidavit. Died on 20th December 2021. The petitioner on her own, my lord, she went there and she collected these documents from the center. She inserted her own name. So that is the statement, and she was warned by the CDPO not to sign her name because she was never appointed. The CDPO's affidavit is clear on this. If my lord comes to the CDPO's affidavit. Para 4, my lord, page 32. Para 4. The deponent denies the statements made in paragraph 2 of the writ petition. Answering deponent further states that it is not correct that she was working as an Anganwadi worker at Pohukata Anganwadi Center number 21. After all, nobody from the undersigned office had allowed her to work as Anganwadi worker in the said AW center, as because there was an existing Anganwadi worker, namely late Mona Bora, who was working and serving as Anganwadi worker till her death, that is up to 2012-2021. The monthly report of Anganwadi Center was signed by herself according to her wish, and while the incident came to the notice of the circle supervisor, the circle supervisor warned her not to sign the monthly report in future. My lord, on the basis of this writ petition, my lord, when this honorable court considered this writ petition, my lord, and the order was, interim order was, my lord, granted, interfering with my appointment. My appointment is not under challenge in the writ petition. My lord, however, my lord, my appointment letter was given on 31st of October 2022. My lord, I joined on 1st of November 2022. And my lord, after a month or so, my lord, the interim order was passed. And my lord, an office order was issued on 13th of December 2022, from whereafter I am not working. I had joined in the service, my lord. Those facts were not placed before this honorable court. And in the, if my lord may see the prayer in the writ petition, my appointment was not challenged. The prayer is, my lord, mandamus should not be issued directing the respondent authorities to recall, rescind, or quash the name of respondent number 5 from the list of eligible candidates who applied for the post of AWW under Khagorijan ICDS and on causes so and so by. These facts were not brought to the notice of the honorable court. In any case, my lord, she does not have a case. Her entire case is based on her alleged working in the Anganwadi Center for 2 years. She was never even allowed to work. And the post got vacated, my lord, on 21st of December 2021. The advertisement, my lord, advertisement was issued on 25th of March 2022. My lord, there, my lord, advertisement, they have, sorry. In my IA, I have given, my lord, a copy of the
25/3/22.
So 25/3/22.
It is there,
Just
page 17.
Yes, my lord, page 17 of my I.
No, 70.
70.
Writ petition.
Yes, my lord. Yes, my lord.
What is the IA for?
IA for safe vacation, my lord. An order was passed, my lord, stating that it will be heard along with the, recording my submission that will be heard along with the writ petition. Okay. My lord, may I be permitted to place one judgment, my lord? Para 12, 13, 14, and 15, they record the precedence, my lord. And para 16 and 17, so much. Para 16, it says it is necessary for us to state that state here that in order to check multiplicity of proceedings pertaining to the same subject matter, and more importantly, to stop the menace of soliciting inconsistent orders through different judicial forums by suppressing material facts, either by remaining silent or making misleading statements in pleadings in order to escape the liability of making a false statement, we are of the view that the parties have to disclose the details of all legal proceedings and litigations, either past or present, concerning any part of the subject matter of the dispute which is within their knowledge. And then my lord may come to para 17. In the instant case, since the appellant have not disclosed the filing of civil suit and its dismissal and dismissal of the appeal, so they have not come with clean hands. Here, what I am on, my lord, is they have not disclosed that she was not appointed, she was not allowed to work. She has not disclosed about my appointment when the petition was filed, my lord, in December. So, my lord, on the basis of that, my lord, she has obtained the interim order and no one is working in the Anganwadi center as of now. My lord, the nurse is allowed to, has been permitted to take care of the Anganwadi center. So what I would be on, my lord, since misleading statements have been made, my lord, the petition needs to be dismissed, my lord.
Yes.
My lord, kindly may come to page number 13 of my writ petition, my lord. That is in lecture B, my lord. This is the monthly report, my lord. That is an English version, my lord.
Yes.
That is from 1/1/2022 to 31/1/2022, my lord. There are my signatures, my lord. I cannot just go and sign a registered copy like this, my lord. I have already been working, my lord, even though I haven't, I have some other documents regarding this from which I am working from 2019 to 2020, my lord, that I have not annexed. My lord, my client has said that she has some other documents also regarding that she has been working from 19 to 20, my lord. And even though, my lord, after working for 2.5 years, and my lord may come to page number 64, my lord. Writ petition, my lord. She has been eligible to appear in the interview, my lord. As though she was already working for 2 years, 4 months, my lord, and she was already eligible to appear in the interview. After appearing in the interview, she appeared in the interview, then she was rejected for a ground of overage, my lord. She was already working. She was a layman, my lord. She don't know about the overage. And the post she was working, it was a vacant post, my lord. They have been waiting a long she turned overage and they could conduct the interview, my lord. They could have conducted the interview earlier, my lord.
I'm not been able to follow why a person who is in permanent employment would apply again for another job.
My lord, she was working temporarily in the post, my lord. That post was vacant, my lord. And they have conducted the interview, my lord, where she was eligible to sit in the interview. And she had appeared in the interview, my lord. My prayer is only that, my lord, she was already working. And that cannot be denied that she was already working and she put her sign and signature, my lord.
No,
and
the denial has come from the CDPO. Denial has already come.
My lord, being a poor lady, she was already working, and after that, she has been rejected on the ground of overage, my lord. How can she know that she will become an overage and she'll be rejected, my lord, as though she was already working on that post? And she was slightly overage for the 4 years, my lord, 44 years and 11 months, my lord.
December की तो उल्टा उल्टा है। December की तो उल्टा उल्टा है। No affidavit here, no.
And my lord, the post was vacant and they have not filled up the post, waiting for 2 years, 4 months to fill up that post, my lord. Where she was already working.
Yes.
Okay.
The advertisement is clear, my lord, up to 44 years. She has not applied for condonation. She has not even annexed my lord, the advertisement.
Yes, Mr. Gauss.
My lord, I will just, 2 quick points, I will just, my lord, place before the court, my lord. My lord, we have filed an affidavit. The affidavit by respondent number 4, my lord. In para 4, my lord, we have stated that until 2012-21, one Monabora was working, my lord, as a worker, my lord. So there was, so a situation doesn't arise when already we have a my lord person working in the post that she will come and work. On 2012-21, my lord, that Monabora died. Thereafter, my lord, we have come up with an advertisement on 25/3/22. So, my lord, it's a within a span of 3 months. We have come with an advertisement for filling up that post.
25/3.
25/3/22, my lord. That is on record, my lord, in my affidavit. Less than 3 months we have come. Because, my lord, these are the posts, my lord.
She died on 2012-21.
She died on 2012-21. So, my lord, in serial number 2, the conditions laid down that she has to be between the age of 18 and 44. That is the parameter, my lord, age in qualification that has to be there. So later on, my lord, we have found that she is 44 years, 11 months. Basing on that only, my lord, we have rejected her country nature. Because, my lord, if you go the guidelines even, go to guidelines. My lord, I'm just placing a notification of 2019, my lord, with your lordship. That is the okay. And one thing, she did not, my lord, challenge that clause of age. Neither she have filed any application before authority for condemnation of her overage, my lord. Nothing, my lord. Nor she has come before this honorable court seeking, my lord. Yes, my lord. So, my lord, that is there, my lord. So,
Unofficially, she has been assured that she'll get the, she'll face the interview and she'll get the post, my lord.
Which page is annexure D to your writ petition?
It's 61. So 61. That's native.
Did you apply or you did not apply for the post?
My lord, I am eligible, my lord. That is in annexure 64, my lord.
My question is different. My question is
My lord,
whether you applied for the post or not.
my lord applied.
You applied.
My lord, I
Look at paragraph 3.
my lord. Writ petition, my lord.
Yes. Look at paragraph 3 and 4.
My lord.
You just got a notice to appear in the interview.
My lord.
In the next para 4, you say that on the date you were required to submit the application form.
My lord.
So you applied when you applied before that or after that? Yeah, para 4 is before para 3 or para 3 is before para 4.
My
What
lord,
is the
para 3, that the petitioner received a plain notice, my lord. I received only a plain notice, my lord.
correct? So you did not apply at that day.
My lord.
You got a notice to
My
sit in the oral interview without applying.
My lord, I did not receive the advertisement, my lord. I
It's
just
okay.
received the plain notice, my
No.
lord. By looking at the
Trying to
plain notice.
understand para 3 and 4. I'm trying to understand. You got a notice
My lord.
to appear in the interview.
My lord, notice was hanged in the office, my
It's
lord.
okay. Whatever process,
My
you
lord.
got a notice to appear in the interview.
My lord.
My question is that whether you applied before that or not.
No, my lord.
You did not apply.
No, my lord. By looking at that notice, my lord, I appeared in the interview, my lord.
My lord, my affidavit reveals that, my lord, she filed an appeal. And basing on that, we allowed her. That is what stated, my lord. The unsworn deponent states that considering her appeal to appear in the interview, the petitioner was allowed the same. But after scrutinizing of all her original documents and testimonials, it was found that she was overage 44 years, 11 months, which were recorded in all our interview records, and the upper age limit for the post of Anganwadi worker was 44 years. As per the government guideline.
Interview was conducted, my lord.
That is appeal. So application, no, you are also silent.
My lord. No. In the previous para, my lord, we stated that the deponent states that the name of the petitioner was not listed in the eligible candidate, but she was allowed to appear in the interview. Meaning thereby, my lord, she was not in the list.
The position is right. He did not appear on the basis of an application form. Apparently, she did not file an application form.
On an appeal. And she was allowed to sit for the interview, my lord. And on the ground of overage, my lord, it was rejected.
My lord, they have allowed me to sit in the interview. After conducting the interview, they have rejected me on the ground of overage, my lord.
Okay.
My lord, she was allowed to sit, means, my lord, we have scrutinized the documents. That is what we said in the affidavit, my lord. If you read it.
No, but that is something which the department is doing. One case has come to court. But that means that pick and choose basis, you allow people to sit in the examination without
My lord.
interview, without application. This is what is happening in your social welfare department. There's an advertisement to apply and you are considering it without those applications.
Since she filed an appeal, my lord. Considering her appeal to appear in the interview.
It was in a moral science, what you call, in a school prayer it was, give us a deliberate. Then it said, also said that thy kingdom come. So kingdom is of the God. However he wishes he can please people. Here also same things are happening.
But my lord, the parameter remains that she was of age on the date of that application, my lord. She had to be between 18 and 44, my lord.
But my lord, she was already working, my lord.
She was not, that is,
My lord,
that
she
is,
was
that
already
is,
working, my
That
lord.
is the tragedy, you are not working.
that is what we have clarified,
No,
my
my
lord.
lord, I have another document regarding that, my lord, if you may peruse, but it was in my,
My lord, how
Answer,
can
my
she
lord.
can
Show me, you receive, you must have received.
appointment
a-
letter, let her
No,
show her
no,
appointment
no,
letter, my lord.
You must have received honorarium.
If he is working, she has must have received some money. And my lord, how can, without an appointment letter from authority, how can she, my lord?
No, that's why thy kingdom come. You can show that she is receiving, then she makes out a case.
my lord. Can I get some time, my lord, to produce certain other documents also regarding that, my lord?
Fix it next week then.
My lord,
Let him bring it on record.
my lord.
My lord.
But this interim order I'll vacate.
Fine.
Pass
Fine.
notice,
Suffering.
I'll
Next-
vacate
Next
the interim
week, my
order.
lord.
No. Application for interim, when there is an application for vacating, I'll vacate it based on the affidavit of the state. But we'll consider your case. This court has passed an order that the petition be also disposed of. I'll be deferring that disposal of the petition. Not noticing changes.
Deeply.
Interim order would be vacated, man. You have served extra copies to them?
Yes.
Okay. Yes, you have instructions. You once play claims promotion.
Lordship, this is my instruction.
What does it say? Tell me, what does it
Yes.
say?
Lordship, the petitioner is not belongs to that village, Lordship, revenue village, which is mandatory for the promotion, Lordship. And therefore, further that Lordship.
No, you see, the Mr. Goswami, as per statement made in the writ petition, somewhere is stated that the transfer of that her transfer was made pursuant to the High Court order.
No, no, my lord. She was transferred in the public interest. The transfer order is at page 23 of the research.
She was transferred in public interest.
Yes, the
Okay.
order says. So not in
So
person.
what is the distance between, what is the
the-
distance
the-
between the area?
No, my case is, my lord, simply is that this advertisement, which is issued for fresh recruitments, is in contravention of the clause 10 of the guidelines.
No, no, you see, I'm asking you in context of the objection made by Mr. Goswami,
One of the,
that you are not the resident of that area.
yes, one of the Anganwadi centers is within my village, and I am a resident of that Anganwadi center, covered by that Anganwadi center.
Called by that area.
Yes, this is the
The advertisement is at page 30, my lord.
30.
30.
Yes.
It is. Okay. Yeah, 30 is the Anganwadi center. It starts from 29.
Yes.
The Anganwadi center 219 Jaipur part 2 Manipuri Muslim Basti.
Yes.
This is the Anganwadi center who within the jurisdiction of which I am living. This GP certificate that certifies my residence is at page 26.
26.
6. It says inhabitant of village Jaipur part 2.
You better file your affidavit then.
Lordship.
Both sides are to be represented. On the prayer made by Mr. J.K. Goswami and additional senior government advocate. 3 weeks time is also there. 3 weeks time is granted to file affidavit in opposition in the matter. List after 3 weeks.
Can you date me, please?
Give a date. It's not a-
$15,900.
16 59.
159.
26.
Obliged.
You given extra copies?
We have, I have been told that we have served it.
No, I don't know. Was it
One
last?
copy has received, Lordship.
Huh?
Agriculture for a copy was.
We'll then, but we will fix it. Shortly we'll give it by today.
Lordship, is
But
that-
I had inquired, Lordship, I have been told that it was served, but it's okay. If they have not explained, serve it again.
One copy I have received, sir.
Because he'll have to get instructions in the matter because this is a case where instructions are required.
Lordship.
So what has happened during the pendency,
Yes.
the earlier final gradation, what has happened, the provision, our name appeared in the provisional gradation. List. In the final gradation list, our names did not appear. Now, during the pendency, a fresh gradation, final gradation list have been issued, Lordship. And abandoning the earlier gradation list without any draft.
So
Without
then
any
you have to
draft.
challenge it. You have to withdraw this petition and then.
No, Lordship, this petition would remain. This petition was challenging the order and the gradation list. Now, the order, challenge to the order would remain, but for this, we have to challenge it again.
You have a consolidated petition. The two petitions are not required. You see, this has become infructuous if you are saying that. If the earlier gradation list has been withdrawn with and substituted by another gradation list.
I don't know whether the earlier was withdrawn or not, but there is a fresh gradation list. That is correct.
Then you merely adjourn it, you take instructions.
Yes, yes.
In the meantime, you serve copies to them. Mr. BP Borat and the counsel for the petitioner submits that he has been informed that during the pendency of this writ petition, another gradation list has been prepared and published. First of it is submitted that he is not aware as to whether the earlier gradation list has been annulled, oblique set aside or recalled. First of Miss S. Kemprai Leonard, standing counsel for KAC, and Miss
G. Bora, Lordship.
G. Bora,
Lordship.
counsel for
Agriculture Department, respondent 1 and 5.
Agriculture Department, submits that she has not received requisite extra copies of the petition.
Lordship, I have received 1 copy.
Okay, so how many you need?
Another one.
So this is what I said, you listen to me. I said requisite extra copies were not given.
Lordship.
One is not
Sorry,
sufficient.
excuse- sorry.
No, it's okay. First, accordingly, requisite extra copies of the petition is served on the honorable standing counsel for Agriculture Department and Carving Law Autonomous Council by tomorrow.
Yes, by tomorrow.
By tomorrow. This after?
But one date may be given.
When?
At least after 1 week.
4 weeks, Lordship, we have to take an instruction.
No, because he'll take instructions. If that
Lordship,
is
Lordship.
not there, he'll withdraw the petition, then come again. Because two repetitions would be
Lordship, date of the latest gradation list is 27/7. Lordship, date of the latest gradation list is 27/7/23.
27/7/23. Okay, this after a week.
27.
Here we are yet to receive our instructions.
27.
This matter is covered by the judgment of the Honorable Court. I have the next page number 41 regarding the minority of the petitioner at the time of death of his father, my lord. And this Honorable Court held that, my lord, this ground, my lord, cannot be rejected, my lord. Petitioner's father expired 2007, my lord. On the same year he had applied, and but for not considering, he had approved this Honorable Court in the year 2011, my lord. The first order is there, my lord, page number 15. And my lord,
Page number
15, the first order, my lord. For consideration as per Achyut Ranjan's, my lord, guidelines, my lord. Accordingly, my lord, if we had, along with this order, he had again approved the Honorable Court.
just a moment.
Yes.
Just a moment. That is the only point involved.
Yes, my lord.
That is the only point.
Yes, for my lord, last rejection, my lord, page number 38.
Then your petition will be liable to be dismissed despite the order of the coordinate bench of this court. You bring it on the next date. You note down the citations. One is the case of Sanjay Kumar, Supreme Court. And the other case is Alok Kumar of the division bench of this court, where the Supreme Court judgment has been followed, and it has been held that there cannot be a reservation for minor when it comes to compassionate appointment. And therefore, both of these cases were not found. I don't find it being referred to in the judgments which we have cited here. So that will be a judgment per incurium, and it will not be a good law. I may not follow it.
Go through.
Go through it. Alok Kumar is Guwahati High Court decision, division bench. Sanjay Kumar is that division bench, Supreme Court judgment. Just find it out. Both sides are duly represented. On the prayer made by Mr. Ardhar, then an additional senior government advocate, list after 2 weeks so as to enable him to obtain appropriate instructions. You also go through that list to judgments and be prepared on the next date.
Like
28.
Yes.
In this matter, we need 3 weeks time, my lord.
for instruction, my lord.
Just now.
My lord.
This is a case for regularization,
Regularization and some wages, my lord,
Non-payment of regulation.
non-payment of wages.
and also regularization.
You were appointed when?
Some of the petitioners in 2005.
But then you would not be covered by the cabinet decision of this state. Not 11493.
But those who are my lord, there is working, they should not be disturbed as of junction.
That will see it's a work-based. That will hear it. How much time?
3 weeks time.
3 weeks time. Okay. 28. Both sides are delayed. On the pyramid by This is the first standing council for forest for the
Panchayat and
Panchayat and Rural Development Department. This after 3 weeks, just to enable him to file affidavit in the matter.
Obliged.
29.
Over a date.
I'm not giving a date. After 3 weeks, make a mention if it is not listed.
A matter relates to compassionate appointment. Here, the case of the petitioner has been rejected by the SLC after DLC has recommended its case. Your Lordship. DLC recommendation, Your Lordship will find at page
No,
24.
you just have to show us that there are vacancies existing and they gave a false report.
While recommending his name, there was vacancies. Your Lordship. Kindly page 24. Your Lordship. Page 24 is the at point number serial number 4, Your Lordship. Selected candidate.
You see, that doesn't help you.
And the page.
I'll tell you why.
At page 23.
At that point of time when the recommendations were made, those were in 2008. Correct.
Yes.
And when the SLC is taking up the matter, there's a new memorandum which is coming. 2008 would no longer be applicable.
But after recommendation in the year 2008, Your Lordship, his case had not been placed till 2015, Your Lordship, before the SLC, Your Lordship. And when his case
But
was
then it is
placed,
your duty to find out whether which vacancies are there.
at the time of recommendation, Your Lordship, there was vacancy, Your Lordship.
That's 2008. Now we are in 23.
And while recommending, while rejecting his case in 2015, Your Lordship, there was office memorandum dated 1/6/2015 has already came. SLC could have recommended on the basis of that memorandum, Your Lordship, at clause 15, Your Lordship, which says that other vacancies in other department can also be considered.
You see, whatever is done, the vacancies are relatable to 2008. Correct.
Yes, Your Lordship.
2008, if there is a vacancy, shows that there is a vacancy.
Yes, Your Lordship. That kindly page 23, Your Lordship.
23.
23.
No, 23 is the position of 2008.
2008.
Now we are in 23. Mr. Mira, show us the vacancy available now. 2008 vacancy, if it is there, you also have to show me that 2008 vacancy was left aside. It was never filled up.
Then I may be allowed to file an RTI in the meantime.
You do whatever you like, but you see, there must be an existing vacancy where you can be accommodated, and the vacancy should relate to the period when your father died. If there is a vacancy today, can you be considered for today's vacancy?
No, you at the time.
No. Then you see, number two, I'm just making a comment. Let us say that in a particular department, there is a cadre strength of, say, 50. Correct. Just like the foreigners tribunal case we were dealing earlier. The government had created 200 posts, but they now say that we don't need it. Can there be a mandamus of the court saying that you fill up the post? If the government doesn't want to fill up the post, then you see there should be a vacancy, and unless you show that there is a vacancy relatable to the year 2000, your father died when?
2017.
16?
2017.
So it should be a vacancy of 2007 and 8. You can merely adjourn it. You try to find out if there is a vacancy of that time. You give him time, let him find out if there is a vacancy available. Because Mr. Mira, the amount of cases we do for compassionate appointment, I don't think there would be any case, any vacancy left out. Every day, if I am taking up 15-20 cases, 210 working days would make it 8,000 cases. Uh, 2008, 2023 is how many years? 823, 15 years. 15 into 8.
Lord,
120,000 cases.
40% of the bench 3 methods.
No, I don't know that, but I'm just making a rough calculation. With that amount of litigation, to have a vacancy of 2007-8 appears to be impossible. But still, we are giving you time. Both sides are duly represented on the prayer made by Mr. K. Mira, counsel to the petitioner. List after
3 weeks.
3 weeks, so to enable him to obtain appropriate instructions.
Party.
This is also a matter related to compassionate appointment.
Which year? Father died when?
Father died on, not died, Your Lordship. He was medical, voluntarily died on medical grounds.
Medical, okay.
Thereafter, she filed an application, and what happened, Your Lordship, kindly peruse page 31, Your Lordship.
Then you'll have to file your return if it is
Yes,
medical.
Lordship, I have to file the affidavit. Affidavit is ready for sending for vetting. Lordship.
How much time?
2 weeks.
2 weeks, okay. Both sides will be presented on the prayer made by Mr. J.K. Goswami and additional senior committee advocate.
All the respondents.
List after 2 weeks to enable, so as to enable him to file affidavit in opposition in the matter.
Party 2 to 35.
These matter pertains to, my lord, the termination of the petitioners, my lord, without following the, my lord, the principle of natural justice, my lord. And your lordship has disposed of the similar matter, my lord, on the relying on the Ali Ahmad Borbuyal, my lord, judgment or order was I quote, my lord, may I submit a copy, my lord. All the petitioners, my lord, terminated by the same order of the same date, my lord, different order of the same date, my lord. On the same allegation concerning same Gaon Panchayat, my lord. Allegation on the basis of their arrest, my lord, in the criminal case, my lord. Only reason is that they were arrested, my lord, in the criminal case.
Yes.
Lordship, this case will not cover the cases of the petitioners, my lord. Lordship has passed an order on the last Friday, my lord. The similar case, my lord. They have simply, with simplicity, they have released, my lord. There is no stigma, my lord. No stigmatic order, my lord.
Where is that?
Page number, my lord, 64.
No, still you have to file an affidavit if you want to contest
Yes,
it.
my lord. We will file affidavit.
Page
64, my lord.
54.
64, my lord.
64.
Yes.
Okay, you file an objection then.
Yes, my lord. We have objection.
2 weeks.
My lord.
Both sides are duly represented on the prayer made by Mr. Datta, Study procedure for PNRD department. List after 2 weeks so as to enable him to file affidavit in opposition in the matter. Take back this citation.
Pray for a fixed date, my lord.
Date I'm not fixing it right now.
My lord.
Make a mention if it doesn't come.
32 to 35 and also supplementary. list,
60, my lord. 60.
60.
Connected, my lord.
Okay.
Yes.
Same. Make a
Alright.
mention if it is not listed.
Obliged. My lord.
I don't know, I brought the similar as well.
You got it? Same order.
Logic. My lord, one thing, my lord, here I am claiming third MSCB benefit. Here I am third MSCB benefit claiming their promotion. Others same, my lord.
Okay. This is third MSCP.
Yes.
You became entitled when?
1st September 2018.
1st September 2018.
18.
The ACR is of which?
16 and
The
17. 16, 17.
16, 17 is the adverse
Yes.
entry.
Yes.
What was your grading?
It's average.
Average. Okay.
That only thing that lordship, our stand is not adverse entry, although lordship Devdutt and it's not, from our
Okay.
side, it's not an adverse
Yes.
entry.
Okay. Okay.
My lord. In their affidavit, they have said, my lord, that it was not communicated. In affidavit, they have said.
Disposal.
My-
59. My name may be corrected, lordship. Obliged.
That is what in fact I was writing.
Maybe. In this case, by order that. In 2023, my lord, the government advocate was trying to take instruction, my lord. Instruction to order.
Yes, what has happened? Deputy Commissioner's instructions was to be produced.
After some time. If my matter of revenue department, I just handle.
Now this will be vacant post of senior assistant in Kayan Revenue Circle. So it has to be revenue, I think. After some time.
Yes.
54 to 56, stay vacated.
Lordship,
Well, before starts, my friend, senior friend, Charles Lordship. In item number 55, Lordship, and for the respondent number 8, he has already expired, retired Lordship. Item 55, Lordship,
55.
respondent number 8, my lord, he has already retired Lordship. Cause of action does not survive.
There are 4, out of 4, one has
Yes,
retired.
expired,
Retired Lordship.
retired, okay.
So, no cause of action survived.
Out of 4, one has retired.
Okay,
My lord, in this case,
okay, we'll take note of your submission.
Lordship.
in this case, my lord, actually, I am for the solitary private respondent. Last time the matter came before the other court, I filed an IA. And after hearing both sides, the court felt that it is a matter which has to be finally disposed of by the interim order. By the interim order, 3 posts of my lord, environmental scientists in the pollution control board were directed not to be filled up. I am the next below post, senior most. My promotion will be to there. So I submitted that, my lord, blocking the 3 posts will neither be in the interest of pollution control board nor in the public interest. Therefore, it was decided and it was suggested that the matter may be finally disposed of. However, my lord, I am for the respondent. If the main matter, here the same length of argument will be necessary for the stay vacation, let me be fair enough. And for the writ also. There are no factual disputes, only interpretation of some statute. But Mr. M.K. Chaudhary appears for the petitioner, my lord. He has to start first.
He's there, he's ready.
M.K. Chaudhary.
In fact, before the petitioner starts, let me submit that in connected item number 56, that is petition 8263. Here, in fact, affidavit on behalf of the Pollution Control Board was not filed. So I have filed it today. It is not on record. I have already served to the party respondent.
You're giving it to Mr. Sharma?
No, they are not the party. Parties.
Okay.
For the petitioner, I will there.
Okay,
And they have filed a petition opposition matter.
you're ready for hearing?
But in the matter, parties matter, stipulating matter.
No, not stability. Mr. Barbara is saying that the court has already observed that it should be, the entire matter should be heard. You are ready for hearing?
It's for them to start.
Yes.
You just give me an extra copy, we'll call it in the meanwhile.
Okay.
Yes.
Your Lordship, the impugned order, item number 54, Your Lordship, the writ petition.
First one,
Yes. 5902, Your Lordship. Five nine zero 2020. Page 40.
page
5902. Page 40, Your Lordship.
40.
Annexure I, Your Lordship. Your Lordship, please.
This is promotion order,
This is not a promotion order, this is a demotion order. Your Lordship.
demotion order.
Demotion.
Yes,
Yes. Your Lordship, there are 4 sub-orders in that order, Your Lordship. The first order pertains to one Sri Ranjan Bodolo, Your Lordship, who is the respondent number, petition number 1, Your Lordship. The second order is pertains to Sri Karamjit Nath, who is the petition number 2, and the third pertains to one Sri Manoj Bodwa, Your Lordship. Both of the all 3 of these petitioners, Your Lordship, they were reverted from the post of environmental scientist to the post of assistant
okay.
environmental
This
scientist.
Jivan Sarkar has not come.
Jivan Sarkar is not a party, Your Lordship. He had
He has accepted it.
He has accepted.
He has
He
retired.
retired also, Your
He has
Lordship, before
Okay.
the petition before Your Lordship.
He attained
So Ranjan Bodla, Karanjit Nath and Manoj Borua are before Your Lordship. And the prime grievance, Your Lordship, is in regard to their demotion from the post of environmental scientist to the post of assistant environmental scientist. Now, for background, Your Lordship, I'll just prefer the service to the pollution control board, Your Lordship.
Services I have, somebody has given it here.
Yes, yes,
Huh.
yes. If Your Lordship can kindly for a moment come to table 3, just for Your Lordship's ease of preference.
No, just a moment.
Yes, sir.
You see, this is an order of reversion.
Yes,
Where is the earlier order of giving you promotion?
yes. Your Lordship would kindly come to page 24 for a moment, Your Lordship. Page 24.
It's upgraded.
Yes. In fact, there's a background to the order at page 24. The post, Your Lordship.
Can you just?
Yes, yes.
Is any connected matter I have handled with it earlier? No.
Yes, there was a paper, my lord, the petitioner in the other 2 cases, he was given a retrospective promotion from a date he was not born in the other. That was put to challenge by the respondents in the other 2 connected cases. That Your Lordship allowed, my lord.
Okay. Because documents appear to be familiar.
Yes, my yes.
Okay.
Yes, Your Lordship, for a background, Your Lordship, I implore Your Lordship to come to page 22, just as a background, the entire batch of promotions. Page 22, Your Lordship.
Page
22.
para 22.
No, page 22.
Page 22.
Annexure B, Your Lordship. This is an order, Your Lordship, dated 7th of April 2012, where the Respondent Pollution Control Board redesignated.
I hope that the earlier order, Mr. My earlier order.
Yes.
It won't be an impediment for me to take up the matter. No.
May not be, but that was for a different cause of action, my lord. And
No, I'm just asking you
Yes.
because if the decision would be relevant consideration here.
I'll rely on the judgment otherwise, my lord. I am
Okay.
not-
No, reliance is something
Yes,
else.
yes.
But if it doesn't impeach the factual issue,
This is all the subsequent cause of action, my lord.
it's okay.
Yes. By notification, Your Lordship, dated 7th of April 2012, the Respondent Pollution Control Board redesignated certain posts. What is relevant, Your Lordship, is in the last paragraph, Your Lordship. In between the ranks of Assistant Environmental Scientist and Assistant Executive Environmental Scientist, the board has approved a post of Environmental Scientist for direct recruitment of science postgraduate, as well as for promotion of chemists with BSc degree, which is presently not held by anyone and therefore not shown in it. So by dint of this order, Your Lordship, one post was created called the environmental scientist. Thereafter, Your Lordship, on 23rd of September 2013, there were 7 incumbents in the Pollution Control Board who were provisionally promoted to the post of environmental scientist, Your Lordship. That is at page 23. Yes, page 23, Your Lordship. The 7 incumbents in the lower cadre, lower post, Your Lordship, were promoted to the post of environmental scientist with immediate effect. The pay and promotional benefit will accrue to these scientists with retrospective effect only after approval of upgradation by the board. your lordship would recall the earlier page, your lordship, where it says that it is for promotion of chemist with a BSc degree. Now thereafter, page 23 is before your lordship. With 7 incumbents, your lordship, we are provisionally promoted. Out of these 7 incumbents, your lordship, serial number 1, serial number 2, and serial number 4 are before this honorable court by way of as petitioners in this writ petition, your lordship.
Yes.
Yes. Thereafter, your lordship would kindly come to page 24 for a moment, your lordship. Page 24. The earlier provisional appointment, your lordship, promotion, in fact, was confirmed with respect to the petitioners before your lordship as environmental scientist. The first line, the last line of the first paragraph may be important in this regard, your lordship. The pay and other promotional benefit will accrue to them with effect the date of their joining as per the board's order number so and so dated 23/9/2013. The earlier provisional promotion, your lordship, was 23/9/2013. So in respect of the petitioners, their promotion was sought to be given effect to when they provisionally promoted to the post of environmental scientist. The first paragraph, your lordship, of page 24. Your lordship sees that? Yes. Thereafter, your lordship, the Pollution Control Board comes up with the Pollution Control Board Assam Employee Service Regulation 2012, which is at page 32. The regulations, your lordship, are notified on 24th of February 2014. Although the rules were termed as 2012 rules, your lordship, they came into effect from the date of the notification, which is 24th of February 2014.
The rules.
The regulations. The
Regulations.
The regulations, your lordship. The regulations are at page 32, annexure H.
Employee service regulations.
Yes, your lordship.
Yes.
Yes. Now, your lordship would kindly come to page 38, your lordship, the relevant portion that guides the service conditions of the petitioners, your lordship. Page 38, for a moment, your lordship. Page 38. Qualification, experience, and promotion of employees of laboratory and scientific service. Your lordship sees that? Yes. The last paragraph, your lordship, the last paragraph. For recruitment to the cadre of environmental scientists, the minimum qualification shall be MSc in chemical, biological, life or environmental sciences from any Indian or foreign university or institution recognized by the government of India. This is not applicable to us, your lordship. We are promotees. The next page, your lordship. The promotional criteria for assistant environmental scientist and environmental scientist, which we were, your lordship, prior to our demotion, to the higher cadre shall be as per table 3 in appendix 3.
No,
yes.
Just clear my concept.
Yes, yes.
Promotees, the earlier notification said you are upgraded.
You are upgraded. You're upgraded.
Upgraded and promotion are same thing?
Yes, yes, the same thing.
No.
Why is this relevant, Your Lordship? Is that they use the word upgraded in the first order where 7 incumbents were promotionally promoted or upgraded. I'll rather use the word upgraded. Thereafter, Your Lordship, when this order was settled by the PCB, it says that in pursuance to the decision taken in 96 board meeting under so and so, the 4 senior assistant environmental scientists are allowed to hold the upgraded post of environmental scientist with effect from the date of their joining, from 23/9/2013. It is for my learned friend in the PCB to clarify whether upgraded or promotion would be different to the word as they imply, Your Lordship. My submission before this honorable court was that they were holding the promoted post of environmental scientist since 12th of August 2014 as per their confirmation, and they have been deriving their pay in that cadre, Your Lordship. In fact, page 24 itself, it says the third column is that date of joining as environmental scientist, which is 23/9/2013, and it's applicable for all the 3 petitioners before this honorable court. Yes. Now I take back your lordship's attention to page 39. The promotional criteria for assistant environmental scientist and environmental scientist to the higher cadre shall be as per table 3 in appendix 3. Now, your lordship has the regulations. If your lordship can kindly come for a moment to table number 3, your lordship, which lays down the relevant page 34, in fact, your lordship. Page 34.
Table 3.
Table 3, your lordship, at page 34. Appendix 3. Table 3 being appendix. Your lordship sees that? Yes. Environmental scientist comes under serial number 6, where the remark for qualification is stated to be for promotee scientist, the qualification shall be BSc only. And admittedly, your lordship, the petitioners are BSc holders. There's no dispute to that. We are BSc holders. There's no dispute to that. Now, the rules and the regulations are not very happily worded.
What is EX environment scientist means?
Assistant Executive Environmental Scientist.
Okay.
Yes.
Executive engineering scientist.
Yes.
Okay.
Yes. So we were demoted from serial number 6 to now at serial number 7. Whereas our next higher cadre was post was, your lordship, as Assistant and Executive Environmental Scientist. Now your lordship would come to subclause C on page 39 itself, your lordship. All those AES of the board, Assistant Environmental Scientists of the board, who possess the minimum educational qualification for environmental scientists as stipulated in clause A above, or have completed a minimum of 5 years of service in the board as AES, shall be brought under the category of ES.
Yeah, you're reading where?
Page 39, your lordship. Page 39. Page 39 of the petition. I apologize.
Yes.
Yes. I'll take back your lordship to subclause C, your lordship.
Yes.
Subclause B referred to table 3 in isolation. Table 3 states that it shall be BSc only. Only was the word which is used in the table. Subclause C now states that all those AES of the board who possess the minimum educational qualification for ES as stipulated in clause A above, or have completed the minimum of 5 years of service in the board as AES, shall be brought under the category of ES along with the post, provided that they acquire postgraduate qualification within 5 years of their service in disciplines in clause A above. Now, your lordship sees that there is a slight disparity between the language of clause B and clause C. Clause C talks about a degree of BSc to be supplemented by an MSc within 5 years. Clause B refers to the table 3, and table 3 in isolation states that only BSc is needed. Now, our submission before this honorable court is that we are not guided by the regulations in as much as the qualifications needed for environmental scientists is required. The reason for our submission is this, your lordship. I'll carry your lordship to and fro between 3-4 annexures if your lordship.
You are saying that
The regulations stipulating the MSc graduation degree for ES and AES 6 and 7, serial number 6 and 7, is not applicable in our case, primarily because your lordship would see that the rules in question, the regulations in question, it came into
Just
effect.
a moment.
Yes. Your lordship.
I'll repeat it again. You are saying that qualification mentioned at 39C
39C.
is not applicable for the
Yes.
ES and AES?
In our case, as petitioners, only in regard to the petitioners, your lordship. Only with regard to the petitioners. The BSc degree that we hold would have sufficed, notwithstanding the presence of the regulation stating that a BSc has to be supplemented by an MSc. Be that as it may, the table states that the BSc degree is a sole requirement, but that will be a second leg of submission before this honorable court. The first leg of submission before this honorable court is that the stipulations that mandate whether I should have a BSc or I should have an MSc would not be applicable on the petitioners in this instant case. In any case, your lordship, 26 at page 26 and 27, they were showed the show causes as to why they have the 26 and 27, your lordship, there are show causes which have been served on the petitioners, which states that you have page 26 and page 27.
Yes.
Yes. In fact, I apologize, your lordship, page 25. 25, they stated there's a letter which has been served on the petitioners by the Pollution Control Board, which states that Pollution Control Board Assam Employee Service Regulation 2012, wide recruitment and promotion under Regulation 9A and C. They've completely omitted clause B, your lordship. Under Regulation 9A and C, fixed qualification, experience, and promotion of employees of laboratory and scientific services. As per the above mentioned regulation, all those assistant environmental scientists have completed a minimum of 5 years in service in the board as AES shall be brought under the category of environmental scientist along with the posts, provided that they acquire postgraduate qualification within 5 years of their service in disciplines stated in clause A above. All of you are BSc degree holders. Please let this board know whether you have applied permission to the board for pursuing the postgraduate degree at any recognized university or not. Your reply should reach the undersigned within 15 days. Page 26, again, your lordship. Your lordship would see the dates, your lordship. The first notice was served on 12th of September. There was a 15-day timeline which was given. The second notice was served on 26 September itself, your lordship, without completion of the 15-day notice. Anyway, that is not besides the point, your lordship. Your lordship would see the contents of the letter that as you have failed to furnish reply against the office letter under reference within stipulated time, it is presumed that you have failed to comply with the provision of Pollution Control Board, Assam Regulation 2012. In view of the above, please note that the board will initiate appropriate action in due course of time. That due course of time, your lordship, took them 5 years. Thereafter,
You are showing me earlier page.
Page 26, your lordship. Page 26.
No, now you are in 26. Earlier page you
Page
showed.
25, your lordship.
You showed 27.
25, your lordship. Page 25, 26, and 27. These were the notices which are served on the petitioners, your lordship. Page 25, 26, and 27. Your Lordship.
Yes.
Yes. Page 27, Your Lordship, again, after 5 years, a notice was again served on the petitioners, which states that as per records, you have not acquired postgraduate, that is MSc degree till date. Therefore, you are hereby directed to reply within 7 days of receipt of this letter as to why appropriate action should not be initiated against you by the board for the non-compliance of the rule aforementioned. Our reply is at page 28, Your Lordship. And this is the reply that we'll be basing our submissions on. The fact that the regulations are not applicable to the petitioners in this case with regard to the qualifications of BSc or MSc as needed, Your Lordship.
Just a moment.
Yes, yes.
Your submission is that as per the requirement, it was only BSc which is a minimum qualification which is required. You had that, and therefore there was no necessity. You are not put to notice to acquire a MSc degree,
Yes,
and therefore the qualification which you had,
yes.
is it applicable for this?
Will the regulations be?
No.
Yes.
Is it applicable for this?
Yes.
9(3)(b). 9(3)(b) is this page 30.
Yes.
9(3)(b) you say
9(3)(b).
is excluded.
Yes, 9(3)(b) they have excluded. Our primary submission, Your Lordship, before this court is that we were promoted to the post of environmental scientist without taking recourse to the regulations of 2012.
Please come again. I
Yes.
did not missed it out.
Yes,
This qualification for AES is what? It should be BSc.
it should be BSc, including AES and ES as per table 3.
But then you see,
Yes,
here is a situation where you were having a BSc degree.
yes.
You are upgraded to serial number 6.
6 from 7.
Serial number 6 is environmental sciences, where the requirement is MSc. Now your upgradation was made, but the qualification still for you remained BSc, whereas the entry level here it is MSc. What is wrong in that asking you to have
Yes.
that acquire that MSc degree?
The regulations, Your Lordship, the regulations came into effect on the month of February 2014. Our rights, Your Lordship, the first of our provisional promotion to the post of environmental scientist was done in the month of September 2013, 23/9/2013. Thereafter, on 12th of August 2014, which is after the date when the regulations came into place, I was confirmed to the post of environmental scientist along with petition number 2 and 3, deriving my date of promotion in the new cadre as 23/9/2013. My rights, Your Lordship, my promotion was carried out without any whiff, without any whisper of the regulations to be enforced. The regulations do not strictly specify whether it is retrospective or it is prospective only, as is the case. And my case, your lordship, was taken along with cases to be considered after the regulations that come into place.
So in fact, your submission would be that
Yes,
once you were promoted in 2013.
yes, 13 itself, your lordship, because it gained continuity from
It's
that.
okay.
Yes,
Let me understand your
Yes.
submission.
yes,
2013, when you were upgraded,
yes,
you had BSc and this regulation did not come in force.
yes,
Therefore, now you are saying that retrospectively you can't be asked to
Yes.
have a higher degree.
Yes.
That is in
yes,
fact
that is my submission, your lordship.
okay. We have to continue on Tuesday next. But there are other matters in the board today. We sit on the day for hearing. Fixing it on 22nd.
Yes. 22nd.
Just give me your last submissions again. Your promotion is 2013.
2013, 23rd September 2013, my promotion. Initially, it was a provisional.
Please give the date again.
It's 23/9/2013.
So this.
The regulations came into force on 24th of February 2014.
Twenty-four 2014. Yes, that I have recorded.
Yes, yes. I was confirmed on 12th of August 2014, deriving my promotion from the date when I was initially promoted on 23/9/2013. So that leads to guys, your lordship.
No, approval,
Yes.
approval is 24 to 2014.
The regulations came into force on 24/2.
Ah.
Yes, yes.
Where does this August come from?
12th of August, where I was confirmed, and the other incumbents were sent back to their respective post of assistant environmental scientist, your lordship. That is at page 27, not page 27, your lordship would see. That is at page
So you
24.
repeat these submissions on the next date because
Yes, yes,
I've closed it at 24 to 2014.
Yes.
That the regulations came into effect in 24 to 2014. This
and
confirmation in August.
August
This is where you begin on the next date.
with effect from. Yes, your lordship.
Mr. M.K. Chaudhary, Senior Counsel, assisted by Mr. M. Sharma, Counsel for the
Petitioner.
petitioners.
Yes.
You're also there?
And responded to the other cases, the connected cases, there are 3 petitions like together.
No, you are one of the petitioners, no?
So I have responded to the other 2 cases.
Acha, okay.
Then the petitioner is there.
You are there. And Mr. S. Hawk, Counsel for the, as well as S. Hawk, Counsel for the petitioner. The submissions of the Senior Counsel for the petitioners remain inconclusive. Next, Mr. A.C. Barbara, Senior Counsel, assisted by Mr.
I am, my lord, for respondent number 8 in 5902.
U. Saikia. for the private respondent in WBC 5902.
Yes, there, my lord, I'm respondent number 8. I filed the IA, my lord, as an applicant.
Respondent number 8. And no, it's okay. I'm not. I'll just say the since I'm referring it to the petitioner. As well as Mr. A. Chakravarti, Honorable Counsel for the private respondents in WBC.
5061 and 8.
Private respondent 5061 or 21 and 8263 or 22 is present. The submissions of the senior counsel for the petitioner remains inconclusive. List again on 22/8/2023.
I am, it is respondent number 7, my lord. In
So,
WBC number
respondent number 7 in
5902, my lord.
5902.
2020.
Okay.
Tuesday, date to Tuesday, sir. 25th.
Can it be on
24th, my lord, Thursday.
24th.
Thursday.
Okay, 24th.
Lordship, call the item number 59, my lord.
Oh, not 24th. Just a moment. Not 24th. There's a division bench fixed.
Tuesday.
Then, my lord. No,
Then it goes to 29th.
yeah, that may be 29th, my lord. Tuesday.
29th. Because there's a division bench constituted on that day. 29th.
All right.
Yes, item.
59.
Huh.
Just it was first.
Yes, you got the instructions.
My lord, no written instruction was received by me, my lord. What officer came to me and he told me that, my lord, at that moment when the court order was given to, my lord, consider his case as a copies come LDA, there was no post at that moment, my lord. That's why, my lord, that was not done. Ultimately, he was in 2016, my lord, promoted after taking approval from the Revenue Department as a senior assistant. Now, 2016, he was working as a senior assistant, and he is claiming that in 2005, my lord, I am working in the place of one senior assistant. That's where my promotion should be given effective from that. That is the case. So far, my lord, my affidavit is concerned, my lord, there was no order. He was not given the charge of the, my lord, senior assistant. There was no job description in the deputy commissioner office. Suppose he is the LDA, he is a UDA, maybe do anything work, any work, but office also can do it like that. So no description. There was
Then
no,
somebody will have to file an affidavit.
we have filed affidavit, my lord. We have already filed affidavit.
You filed it.
Yes. And order has been passed. That order was passed by the one of the deputy commissioners. Person to, and he were contempt also. Lordship kindly see page 32 of the writ petition, my lord. There is a order. He is promoted to the senior assistant. Actually, he was not entitled for promotion to the senior assistant. However, considering the orders of the honorable court, my lord, he was promoted to the post of senior assistant, having approval from the Revenue Department. In deputy commissioner, there is two establishments. One is, my lord, Revenue Department, one is GA, General Administration Department. He was working in the Revenue Department as a copyist, my lord. And law says, my lord, he was governed by that is the, my lord, rules. The draft rules also, my lord, this is not a draft rule. Is, my lord, called my lord, the rules may be called the Assam District Copies Establishment Service Rule 1991. So he is claiming rule 67, my lord, he is not applicable.
So he was promoted in the 2016-17 July 2016. And thereafter, what happened, my lord? He petitioner again filed a writ petition, page 34, 11/12/2018. In this case, my lord, court has also directed, my lord, what happened, page 36, disposed with a direction to the writ petitioner to submit a written promotion to the post of senior assistant from an earlier date, which shall be considered by the authorities subject to availability of vacancy on such an earlier date. Earlier date, there was no vacancies, my lord. And he was not employed as a copies come LDA. Without appointing copies come LDA, my lord, his promotion cannot be done. And
No, you see, if I have understood it correctly, come to page 35.
35.
Come to page 35.
Yes, my lord.
Para 5.
Para 5. It has been accordingly submitted that since the court had directed to antedate the promotion from an earlier date, if necessary, and since there are many vacancies available to the post of senior assistant, the petitioner could have been also promoted from an earlier date. This is at that moment what was
No, even if it's not there, since the order of the court has not been modified, you have to create a supernumerary post and keep it and give him that effect of promotion, or otherwise you file a review and then get this order. What do you call it? And
that order was in force, man.
This order is in force. You have to, even if it is because once you admit once there is no challenge to this judgment, you have accepted it.
So
then, if required, you have to create a new supernumerary post and
could have done, could have done. That is some anomalies there. And page 37, Lordship kindly see the order passed by the Deputy Commissioner. Lordship kindly see. Page 37. Seen the representation after this representation submission, seen the representation dated 25/12/2018 submitted by the Soren Talukdar, retired senior assistant of so and so, certified copy of Iman 11/12/2018 passed by the Honorable Court on writ petition 194/2017. This is the second writ petition. Versus I ordered that 11/12/2018 passed by the Honorable Court, petition 194/17. Says so and so petitioner, the Guwahati High Court directed to respondent authority to promote the petitioner retired senior assistant Kolyan Revenue from an earlier date, subject to availability of vacancy of such an earlier date. In this connection, it is also stated that in compliance of the Honorable High Court order, that is 18/8/2015, in an earlier writ petition 137/2009, Sri Satyaban Talukdar had already been promoted to the post of senior assistant by the office order memo dated 13/7/2016. Again, the post fell vacant due to retirement of Abdul Aziz, senior assistant, Kolyan Revenue Circle, on 13/9/15. A roster register of senior assistant of the amalgamated establishment of Deputy Commissioner Kamru are also thoroughly checked and seen that no post of senior assistant were lying vacant before the date of retirement of Abdul Aziz, senior assistant of Kolyanpur Revenue Circle. Senior assistant was retired from service on superannuation on 30th September 2015. So this post fell vacant with effect from 1/10/2015. Hence, the compliance of the Honorable Court's order 11/12/2018 passed in petition number 194/17. That the Talukdar was promoted to the post of senior assistant with effect from 1/10/2015. That was order. The order will pass after second petition. Thereafter, the petitioner went on contempt petition next page, 38. Contempt number 306 of the 2009. In this contempt petition, they disposed, kindly see page 39, the second paragraph. The SK Brokerty London Council for the petitioner submitted now an order dated 13/3/2019 has been passed by the Deputy Commissioner. It is not an actual compliance of the order of this court and only some compliance. Nonetheless, since this court in excess of contempt jurisdiction may not enter into the effect of legality and validity of order 13/3/2019. The Learned Council wishes to withdraw this contempt petition with a liberty to file a fresh and appropriate petition challenging the said order 13/3/2019. Any other further action. As it states, is Bokakoti Learned Council for the petitioner further submits that though the petitioner has retired from service, he is not accepted his salary. On the other hand, C. S. Sharma, learned counsel for the respondent number one, submitted due to salary of the petitioner was although ready to be paid to him, however, he did not accept. Be that as it may, since learned counsel for the petitioner wishes to withdraw this petition with a liberty, the present petition is closed on withdrawal with a liberty as paid for. It is made clear that acceptance of salary would be without prejudice to any rights of the petitioner to challenge any subsequent action. So, my lord, this order, close of contempt, this order has not been challenged by the petitioner in this petition, my lord.
It has been challenged, my lord. They amended it. It has been challenged.
I amended it.
Yeah.
Oh, I have not received the amended.
There was direction of the Honorable Court Justice Suman Shyam, my lord, or amendment of the repetition.
Did you give amended copy to the?
I will second. Amended, yes, sir. Yes, madam. It's arranged it, madam. So this is the fact, madam.
But then you have to create a supernumerary post, what you call,
Notional.
personal to the petitioner and give him the notional benefit. But there's no other way.
Actually, my lord, actually that was not followed. I also, my understanding, my lord, actually they could have, or maybe actually promoted to the post.
No, you could have challenged the order of the court, uncompliable order. If there's no vacancy, the question of promotion, consideration of promotion would not arise.
The copies come LDA dated, they say there was no post at that moment. That's why the first repetition for direction was not complied with because there was.
No, in the first petition, the direction was based on the fact that for 23 years he did not get an avenue for promotion. Therefore, that was held to be bad, and it was held that he should be given the benefit of promotion by antedating it. So the question of the vacancy being there or not was never agitated, and the court said that you consider it as an antedating.
Yes.
So therefore, you have to no other way but to create a supernumerary post. I'm
Otherwise,
ordering that.
Otherwise, they could have come for review or otherwise.
How do you challenge that order? That's not done.
That is the fact, my lord. So my affidavit says, my lord, is acceptable, my lord, at the moment there was no post.
We'll have to direct that in terms of the earlier order of this court, which is
First repetition.
18/8/2015.
Yes. Repetition 137.
This has to be complied with by giving him the benefit of notional promotion, antedating it in terms of the order of this court, and calculate the notional benefit which he will be getting. Financial benefit which he will be getting. Yes. Only that much?
And so, but otherwise, my lord, in a promotion order, this promotion order, my lord, would be from 19. So for Supreme Court says, my lord, the promotion case, my lord, I have done case, my lord. Effect of the promotion. Lordship kindly see paragraphs 7 and 10. May I read it, my lord? It has been held in a series of decisions of this court that promotion takes effect from the date of being granted and not from the date of occurrence of vacancy or creation of post by union so and so case law. And paragraph 9, in the present case, appellant Nirmal Chandra Sinha was promoted in general manager on 29/11/2096, but he claims that he should be deemed to have been promoted with effect from 13/3/96 with consequent benefit. We are afraid this relief cannot be granted to him. It is settled law that date of occurrence of vacancy is not relevant for this purpose. This case is, my lord, otherwise, my lord, this is not entitled. Whenever he is promoted from the date, my lord, he is effect. So, retrospective effect, my lord, small 2 paragraphs order, my lord. দুটা কপি আছে এটা কপি করতে পারিস দুটা কপি আনিছিল বেলেগ ক্লাস দুটা কপি আনিছিল ক'ত ঘৰতে লুকাইছিল দুটা দিছিল চাইটেশ্যনটো দিব পাৰিম মোৰ ইয়াত ধেৰি আছে চাইটেশ্যনটো মই দি আছো পাছত লৈ দেখোন ভৰি দুটা কপি দিয়েছে মোক Hello, 2008 14 SCC. 2008 14 SCC 29. 2008 14 SCC 29. 09. Not 29. 29. 29. I think it's it, no?
Mr. P. Kotogi, learned counsel for the petitioner, as well as Mr. T.C. Surya, learned additional senior government advocate appearing for respondent number
3.
3, and Mr. J. Andy, learned standing counsel for Revenue Department.
1 and 2.
Only respondent number 1. Finance.
2 finance department.
Mr.
Nair.
Nayak. Okay, and it's a P. Nayak, standing counsel for the finance department, appearing for respondent number 2. Next one. Filing this repetition under Article 2, filing this amended repetition under Article 226 of the Constitution of India. The petitioner has received the order dated 13/3/2019, passed by the Deputy Commissioner Kamrup, within bracket respondent number 3. Fixing the date of 1/10/2015 as the date from which seniority to the petitioner to the post of senior assistant was given. Full stop. The petitioner is seeking direction to the respondent authorities to consider his promotion with effect from 1/10/2005. Next paragraph. In brief, comma, the case of the petitioner is that his service was regularized by order dated 16/9/1988. And as the petitioner however, comma, the petitioner was holding the charge of post of senior assistant of Rangia Revenue Circle with effect from 1/10/2005 due to retirement vacancy of the earlier incumbent, comma, and had rendered service till 2009, comma, claiming entitlement to promotion to the post of copyist cum LDA. The petitioner had approached this court by filing WPC 137 of 2009. And this court by order dated 18/8/2015 allowed the writ petition to stop. The relevant paragraphs 20 to 24 is quoted below. Stop. The respondent number 3 by an order dated 13/7/2016 promoted the petitioner to the vacant post of senior assistant of KYAN Revenue Circle with effect from the date of joining. Stop. They said order was challenged by the petitioner by filing WPC 194 of 2017, and this court by order dated 11/12/2018 accepted the submissions made by the learned counsel for the petitioner that the effective date of promotion should have been antedated in terms of order of this court dated 18/8/2015, passed in WPC 137 of 2009. Paragraph 6. Uh, 7 and 8 in this head order is quoted below. The set to orders of the court was not implemented, and therefore the petitioner approached this court by filing Concast C 306 of 2019. And this court permitted the petitioner to withdraw the petition with liberty to approach the court again to challenge the order dated 13/3/2019. Accordingly, this 2019 order you are challenging in this petition.
Yes, amendment.
Just of the next paragraph. Accordingly, the said order dated 13/3/2019 has been assailed in this presented petition filed under Article 226 of the Constitution of India. Next paragraph. The learned additional senior government advocate has submitted that the consistent stand of the state respondents in the proceedings of WPC 194 of 2017 was to the effect that there was no vacancy available earlier, and therefore the petitioner was given the benefit of promotion only when the vacancy arose on 30/9/2015 on retirement of one Abdul Aziz, ABDUL AZIZ, senior assistant working at Kayan, KYN, Revenue Circle. Full stop. In support of his submissions that unless there is a vacancy which is available, effect of promotion cannot be antedated. The learned senior counsel, additional senior government advocate has cited the case of Nirmal Chandra Sinha, NIRMAL Chandra Sinha, SINHA, versus Union of India Others, 2008, 14 SSC 29. The relevant paragraphs. Three to 11 of the said judgment is quoted below. Next paragraph. Accordingly, referring to these above cited case, it is submitted that it is a well-established, well-settled law and service jurisprudence that a promotion takes effect from the date of being granted and not from the date of occurrence of vacancy or creation of post. Full stop. Just in other words, the submissions of the learned additional senior government advocate is to the effect that the previous orders of the court was not compliable. In view of the law laid down in the case of Nirmal Chandra Sinha within bracket Supra. Next one. In the considered opinion of the court, comma, the observations and finding of this court recorded in paragraph 21 of order dated 18/8/2015, passed in WBC 137 of 2009. Culls CULLS, Culls out a case where this court had accepted the contention of the petitioner that ever since his entry into the service as copyist, comma, he has been denied promotion. Full stop. Therefore, this court had directed that the case of the petitioner be taken up for promotion to the post of copyist cum LDA under the
The act.
no, that 1991 full name of that
Assam District Copies Establishment Service Rules, 1991.
Assam.
The Assam District Copies
Paragraph
Establishment
15,
Service
paragraph 15 of
Rules,
that.
1991.
Paragraph 15 of the judgment. it is.
15.
Mention to the right.
Assam District Copyist Establishment Service Rules 1991. Full stop. Therefore, comma, this is not a case of usual a case of promotion, usual promotion in due course. But here is a case that the petitioner was found to be deprived of his of any promotional avenue, and therefore direction was issued to antedate his promotion. Full stop. Next paragraph. The state respondents had allowed the order of this court dated 18/8/2018, 15, passed in WBC 137 of 2009, as well as the order of this court dated 11/12/2018, passed in WBC 194 of 2017, to attain finality without any challenge to those two orders. So therefore, on this, on the said facts, comma, the court finds the present case in hand to be distinguishable on the facts of the case of Nirmal Chandra Sinha within bracket Supra. Full stop. Next paragraph. Therefore, comma, as the orders of the court passed in WBC 137 of 2009 and WBC 194 of 2017. Having not been assailed, the state respondents are obliged to comply with the directions contained in this said order. Next, therefore, in the considered opinion of the court, it is the obligation of the state respondents to create a supernumerary post personal to the petitioner to give effect to the before referred order dated 18/8/2015 passed in WBC 137 of 2009, as well as order dated 11/12/2018 passed in WBC 194 of 2017. Next paragraph. As the petitioner has already superannuated, the petitioner would be given the financial benefit, the financial benefit due to the petitioner on promotion by giving it anti-dated effect. This antedate from when?
He says 2005.
Huh?
He says 2005 he is looking, wanted 2005. But from the retirement of some Polita.
No, but where is it given in the High Court order? High Court order doesn't say that.
Doesn't say so. But I was holding a post, my lord, a senior assistant, my lord.
No, that is not holding a post. You are just
Charge, my lord. I was given
just
charge.
holding charge.
Charge. That is, there is no job description. My lord, he was working on his table. My lord.
Since 2005 onwards, I was working till 2013.
No, but still you are holding a charge.
Charge, my lord.
But what will be the date when you can win the charge?
It's 2014, my lord. Because that post was lying vacant once, this Kasiram Kolita miner.
Kasiram Kolita, yes.
And all along, there was a vacancy was there.
24/1/2014. Kasiram Kolita.
Even the state government also wrote to the deputy commissioner for considering my case, my lord. For promotion with effect from 1 day to
No, but you see, there is a Supreme Court judgment on that point. Number one. Number two, you come to page 38. This is something I missed out earlier when I was detailing the order. Page 38.
Yes, my lord.
Because if page 38 is there,
Hmm.
then your petition has to be dismissed then. In light of page 38, page 38 says that it will be considered by the authorities subject to availability of vacancy.
That's an earlier day.
But if it is not available, then your case goes, we can't give you that
There is
today.
vacancy, my lord. But there was vacancy, my
So
lord.
they say
No.
there is no vacancy.
They say there is no vacancy.
Because I was holding that post, my lord.
No,
This
no, you are
2000.
just holding a charge.
Charge, my lord. So vacant post I was holding, my lord.
No, that was a senior assistant. That was no.
That's not the, that
please.
is not the appointed post.
I understand, my lord. But they have accounted me there itself, my lord, because there was no post of them.
No, the post to which you are claiming, what do you call promotion, that never existed.
Never.
So we are holding post to charge, and therefore after his death, you are accommodated there on the vacancy arising out of death.
Not retirement, my lord.
Retirement.
Retirement.
After retirement,
Because earlier also, in 2005 also, against retirement vacancy I was holding.
No, but you are not eligible to hold that post. So your eligibility can't be condoned by the court without going into it. But if you have been considered and given, then this order at page 38 has been complied with.
Because that vacancy was, when it was filled up, they have never said so, my lord. 2005 vacancy, my lord.
No, that position is accepted because you see, they are consistently saying that the vacancy is not there.
No,
Even in the earlier writ petition, they said that the vacancy is not there, and therefore this court took cognizance of that.
Yeah, I understand.
Because page 38, this is something I missed out earlier.
vacancy is there.
But the factually, but it is not correct because, but when the vacancy was filled
No,
up.
no. You see, read page 37, last line.
Yes, my lord.
The relevancy, I'm getting only when I read page 38.
This court of view, the normal.
37 says, thus, in the event of non-availability of vacancy, the question of unfair denial of promotion cannot arise.
Yes, ma'am.
So this is a categorical finding of fact.
It's my existing agency.
So let me hear it. We'll hear it this point tomorrow. Because if the vacancy is there or not, then we'll have to hear it. Because this is something I missed out, page 38.
In affidavit also, we are denying, my lord.
It's okay, but this is something I missed out. When I started dictating, I missed out this. I'll have to hear Mr. Kotogi on this point. We'll take it up tomorrow. Nah. Acha. So 22nd. 22nd then. Mr. P. Kotogi, counsel of the petitioner. So this DC Sudhya, Senior Counsel, Handik. The argument events inconclusive list on 22/8. Just remind me on the day, page 37, 38. This is something.
There is a disputed fact, my lord.
Huh?
But actually, when vacancy arose, my lord, because our case is that vacancy was all along there. Because they have not said that when they fill up the post.
I will hear you because their consistent standing, even in the first writ petition, is that the post copies come LD post is never existed. Because copies is a different branch and
Yes,
the other is the revenue and the combined post that is not there. We'll hear you, and this is something I missed out. Mr. Zutia, keep this on the next date. Yes, Mr. Hovi.
The application for vacating in time order, madam. Application is there, madam.
The court martial will take care of it because I have a meeting to attend at 4:30.
I think date may be given, madam. Then
The court martial will take care of it.
My lord, in item 40, madam, there is a content petition. My lord, the content petition is now in process because the matter has been disposed of by the director of the directions with a speaking order.
Yeah.
So if any grievance.
You want to
petition
challenge that?
No, he may be, she may be at liberty to challenge it, but it content may be closed.
Okay, just give that order.
Yes, my content may be closed. I'm placing down.
Mr. A.R. Sikdar, counsel for the petitioner, and Mr. Ardhar for the respondent. The young counsel for the petitioner submits that pursuant to during the pendency of the contempt petition, the Director, Women and Child Development, Assam, by a speaking order dated 12/7/2022, has disposed of the
It's a representation.
deposed of the representation of the petitioner in terms of order dated 15/11/2021, passed by this court in WPC 6003 of 2021. The next paragraph, the learned counsel for the petitioner submits that the petitioner reserves right to assail the order dated 12/7/2022. Next paragraph, accordingly, as the order of the court has been complied with, this contempt petition is closed. It's needless to say that if the petitioner is aggrieved by the order dated 12/7/2022, she may assail it in accordance with law.
I am appearing for the respondent bar. One.
Not recorded
My lord,
addresses.
deeply obliged.
Other matters, the court master will take care of it.
Deeply obliged.
My lord, regarding item number 63, my lord,
Just tell to the court
notice
master.
may be issued upon the newly implemented containers.
Item?
Notice may be issued.
Item
63.
63 on the newly implemented respondent numbers.
Respondent number 4 and 5.
Respondent 4 and 5.
I have
notice.
submitted amended cost title
Okay, respondent 4 and 5. Notice. Ms. B. Devi.
by registered post.
Registered post with Devi.